Yes.
Yeah, Lordship. Lordship, I beg to mention one unlisted criminal appeal number 15/2024 for listing tomorrow.
For DB, division
Yes.
bench matter.
Yes, Lordship. Huh?
Let's see if there is any fixed matter tomorrow.
It's,
When is it? Just check up whether there is any fixed matter tomorrow or day after tomorrow. Whenever there is a fixed matter. Yeah. Right?
Oh, we'll just issue notice tomorrow. No problem.
Tomorrow.
We'll just
Wait.
issue notice. Yes.
Made with your lordships.
This is pertaining to the road meeting.
My lord, this is a public interest litigation, my lord.
Finally.
Finally, one has
My
come.
lord, my lord, sees what is happening, my lord. 496 crores, my lord, has been sanctioned by the Ministry of Roadway and Highways, my lord, Government of India.
Body massage all the way around.
My lord,
When you come.
yes, yes. So lordship may kindly page 29 for a moment. This is the technical note put up. It provides, my lord, how the road has to be constructed, pavements, drainage, everything, my lord. It includes a flyover, my lord. I'm not bothering on lordship at this stage with every document. Your lordship will kindly have page 35. For the flyover, my lord, 218 crores, 76 lakhs, 50,000. Then, my lord, pursuant to this, at page 38, this is the, my lord, administrative approval, technical approval, and financial sanction, my lord. My lord will see the amount. 400, this is for the package B, only this section, my lord. There are three packages, my lord. A, the Itanagar section. B, package B is, my lord, from Naharlagan to Nirjuli. Package C is from Nirjuli to Bandardua. We are concerned with package B only, my lord. 496 crore, 46 lakhs and 50,000, man. This was 24th June 2020, my lord. And my lord will kindly see at page 40, physical progress 100% matter has to be completed by the financial year 23-24. That's over.
Yes.
Then my lord will kindly have page 42, my lord. This is the NIT. NIT for both the packages B and C. We are concerned with B, the first one, my lord. 4-laning of Itanagar to Bandardua section of NH 415 from such and such kilometer, package B, my lord. Amount is 426.88 crores. Completion period, my lord, will see 36 months. This was in July 2020. Now, if your lordship sees page 44, from this, my lord, if your lordship see the reference, it appears, my lord, the agreement was drawn up between the EPC contractor on, my lord, 21st of January 2021. So 21st of January 2024, the 36 months is over, my lord. And my lord, I don't need to show the photographs from page 40 onwards, my lord. Takes them to every day, my lord.
So what is the percentage of completion now?
My lord, they have not given that, but my lord, well, our categorical case is that especially from UPR tri-junction to A sector, my lord, where this flyover is to be constructed, my lord, absolutely zero work, my lord. Zero work. 0%. And my lord will kindly see, since nothing was being done, we filed this RTI application at page 71. My lord will kindly have page 72. Two specific queries, my lord. As serial number 6, we ask for this information. Provide details as to the length and starting and ending point of the flyover, and also provide details as to how many post pillars are to be constructed for the completion of the flyover. 7, how much fund has been allocated for repairing the existing NH 415, and why absolutely no repairs has been carried out during the so-called construction. The reply to that is at page 75. Reply to question number 6 at page 76. My lord will kindly see. Design chain is for the flyover. Total length is 3.950 kilometer. Total number of post pillar in the flyover is 147, my lord. And my lord, only half, not even half constructed. There are only 11 pillars that is been erected, half erected, my lord. You will also see. And my lord, the period of completion is over.
Hmm.
Absolutely nothing has been done, my lord. My lord, similar matter, my lord, is aware of the Nagaland, my lord, when this honorable court Sumoto took up the case, my lord.
Now, this
Yeah.
is for the flyover or for the road?
Both, my lord.
Both of them.
For both, my lord.
So is there a separate amount for the flyover and a
Yes,
separate
yes, yes.
amount? How much?
For the flyover, 298, my lord.
Okay.
Yes.
Where is it?
298 crores.
Where's that?
And not only that, my lord, she's also made a query why, my lord, no maintenance has been carried out. They furnished this document at page 77,
Hmm.
10.4. 10.4, my lord. Gross 10.4. This is through the RTI, my lord. This is the only part of the document they have furnished. This is, it appears to be the contract agreement. Page 77, my lord. May I read, ma'am? During the construction period, the contractor shall maintain at its cost the existing lengths of the project highway so that the traffic worthiness and safety thereof are at no time materially inferior as compared to their condition on the appointed date. My lord, last 3 years, my lord, this has worsened. No repairs, they are, my lord, bound by the contract also to carry out the maintenance work, my lord. But this is an interim payer, my lord, I am making, my lord.
Yes.
The road may direct that in the interim, my lord, they carry out. And not only that, my lord, if they don't carry out, 10.42 provides that the government will carry out, and my lord, the cost will be, at least to that extent, my lord, we are seeking an interim prayer, my lord.
We'll take up the matter. Hmm.
My lord,
Pardon? Oh. Yes, yes, yes.
my lord, if I may submit, my lord, the London Advocate General is here, my lord, it's a matter of serious importance, if his good officers can be.
Certainly not an adversary.
Yes,
No,
not
cannot be.
adversary.
Cannot be.
So it's a matter which has to be taken up. It's for all of us.
Yes.
Is it?
My lord, you kindly see, my lord, 36 months over,
At least,
6 months back. my
at least somebody has woken up now.
Hmm.
Better late than never.
Besides this, I think you should also take note of the way in which garbage is being.
Yes, yes,
disposed
my lord.
of.
Yeah, and we plan to in fact see this
Investigate
whether
on
this,
that, well,
even
what's
the
going on.
Itanagar road repairing, nothing has been done. 5-year maintenance, absolutely nothing. But we are filing RTI for that also.
Okay, whether maintenance of the road, see whether we can cover this garbage on the roadside also, whether it can be
Yes,
covered
yes.
with this.
Yes, my lord, absolutely.
single PRS.
Absolutely.
That will take up as the matter
Yes.
progresses.
Yes, my
I
lord,
think
take
that-
sumo
that
take
issue
up that
also.
part also, your
Hmm.
lordship. My lord, the Nagaland High Court, my lord, this is a pending matter, my lord. They have in the interim directed that the maintenance be carried out, my lord. Your lordship is aware of
Nagaland,
that.
Sumoto in Aizawl Belt also,
Yes.
construction of buildings within the roadside cliff.
Yes.
Okay, which is causing landslides
Yes,
in a certain area.
yes. Here also, my lord,
There's
rampant
also
art cutting is
the-
creating so much problem, my lord.
You have to take
Rainy
up
season,
this
all these
matters.
loose arts because the soil here is not good. It's
Come on.
my lord.
So think what to do. It's all for us, isn't it?
Yes,
And we heard Mr. D. Pangin, okay, learned counsel for the petitioner, who has filed the instant in a public interest litigation. Under Article 2 to 6 of the Constitution for issuance of the appropriate order / writ to the state respondents regarding the construction of the road, four laning road of Itanagar to Bandewada section of NH 415 from kilometer 40 plus 430 to kilometer 51 plus 375 package B
Package.
on EPC mode in the state of Arunachal Pradesh for an amount of rupees 496 crores, 46 lakhs and 50,000. The chief engineer, within bracket zone 5, comma, Ministry of Road Transport and Highways, comma, Government of India, issued a notice inviting bids for eligible contractors for four-laning of Itanagar to Bandewada section of NH 415 from kilometer, again, 40 plus 430 to kilometer 51 plus 735 within brackets packet B. And also for four-laning of package C, section NH 415 from kilometer 51 plus 700 to kilometer 59 plus 199. The instant PIL is mainly concerning the stretch of road from Itanagar dash Bulang dash Naharlagun Tri Junction Nirjuli,
Right.
wherein as per the terms of the NIT, the works was to be completed within a period of 36 months. The Learned Council submits that the work was awarded to MS Woodhill dash Srivram within brackets joint venture, and contract agreement was entered with the aforesaid firm as engineering, comma, procurement and construction contractor within brackets EPC contractor close bracket on 21/01/2021. Good stop. Thereafter, MSTK Engineering Consortium Private Limited was appointed as subcontractor for 49% of the subjected contract work. However, even after more than 36 months have elapsed, there is total lack of progress in the execution of the work. Full stop. The Learned Council has also enclosed photographs of the condition of the road within the mentioned stretch of road. This code, instead of this code, we, having heard the submissions made by the Learned Council, find it appropriate to take up the matter and notice be issued to the state respondents.
1, 2, 6.
1 to 6. Yes, anyone who is going to receive notice?
1 to 3. I'll be appearing for 1 to 3.
Okay.
Highway Division,
Yes.
Mr. Saike is this coming.
M. Rathan, led additional AG for the state, accepts notice on behalf of respondents number 1 to 3.
1 to 3. 1 to 3.
Yes, why?
R. Saikia for respondent 4 and
While
5.
Mr. R. Sakia accepts notice on behalf of respondents number 4 to 5, and Mr. M. Kato
D.
accepts
DY.
notice
SG.
on yes, DSYG, accepts notice on behalf of respondents number
6,
6.
7
Note-
and 8.
And anyone for respondents number 7 and 8?
7 and 8, I will take steps. madam.
Okay, steps is to be taken for issuance of notice to respondents number 7 and 8 through registered post with AD within 3
3 days.
days, returnable by 4 weeks. Meanwhile, requisite extra copies of the instant writ petition, PIN is to be duly furnished to the Learned Councils for the respondents. Yes, list after 4 weeks. Yes, please go ahead. Yes, yes, yes.
Number 4 and 5.
You pass the order, it's okay. And then,
In the,
in the.
on the returnable date, the respondent
Yes.
authorities, more particularly the respondents number 3, 4, and 5, under whom it's work under PWD,
Yes, highway.
3, 4, and 5 shall submit a status report, detailed status report with regard to the progress made pertaining to the execution of the project as indicated herein above. Full stop. In the interim, it is provided that before the next returnable date, the state respondents shall take all requisite measures for maintenance of the road in question and make it motorable for the public in general.
Obliged, highly obliged.
Now we have
Next time we come. Yes, next time we come.
Next time we come, maybe we can have a smoother road.
Safer.
After the neighbors side, at least 50 meters they have flex top, I have seen.
No. Yes,
May I please, Lordship? Lordship, I am appearing for respondent number 4. But here the respondent has engaged one counsel, Mr. Raka Vijay Phukan from Guwahati. So today he could not appear because of the miscommunication between the client and the counsel.
My lord, this is
Very
very
bad.
unfortunate. My lord, on the last occasion, the date was fixed in the presence of Mr. Raka Vijay. And last week, I had discussion not once, twice, thrice, that whether you are going.
He was here yesterday.
Yesterday he was here, today also I think he is here,
so he's here, where's he?
not in the court.
Oh,
This is not very,
anyway,
and
He is not there.
this
Ah.
matter is in a very short campus. I have challenged the tender primarily on the ground that there was no publication in the newspaper and that there was no open
Yes.
competition. My lord, we have CPWD manual, we have GFR.
so
Both
it's
these
not
provide.
as per-
Yes, and in fact, my lord, in all the tenders published, it's a tender worth 90 crore. In all the tenders published by other departments and then so this department, paper publication is invariably made. This is the only case where there was no paper publication.
paper publication. Okay, what about this portal? It was supposed to be.
It was not,
published through a
it was
portal
not published
also.
in the portal also.
It is there in the portal.
Only, no, my lord, it is only in their department's website. But there is a difference.
Website, ah.
CPWD manual says it has to be in the CPPP or manual says in the CPWD portal. It was not done either of those.
Anyways, whatever, the counsel for the respondent has to be present. So when, give us a date, maybe before.
On the next day again, they will say something, man. There is no point giving a date to them, man.
Give us a.
This date was fixed in the presence of the council appearing for the other side.
So what happened?
Last week, my lord, I had
Mr. S. Ratan, is it?
No.
Then who, Mr. Rata?
But at last, he is also from council from based at Guwahati. Last
Okay.
week, my lord, I had
Rata
discussion not
Vijay.
once, twice, thrice. And he said he would be coming here. And in fact, he came also, yesterday also he was here. Now, my lord, my learned friend says there is communication gap, these, that.
Anyway,
And in my lord, last occasion, order was passed by some court that endeavor shall be made for disposal of the writ petition. That is how I have come like that, man, prepared.
but what to do if he's absent? We'll fix another date. And then maybe we'll.
And in fact,
We
my lord,
will
I am
make
not
this
challenging
thing.
the
Ah.
work order issue to them. I am challenging the NIT itself on the ground that there was no publication. We did not get any information. Only 4 persons participated, 2 were
So you
rejected.
want a chance to participate in the.
Yes,
interview.
yes,
That's it,
That-
isn't
that
it? A
much.
fresh and I
that
think
much,
issue.
that much.
Anyways. Heard Mr. D. Mazumdar, learned senior counsel, assisted by Mr.
Yes.
S. Biswas, learned counsel for the appellate. Mr. Your good name?
K. Lolet. K.
Mr.
Lolet.
K. Lolet appears on behalf of
Respondent.
Mr.
Raka.
You're appearing on behalf of the
Raka Vijay.
Mr. Ratan Bijoy, who is the leading counsel in the instant case
Lordship.
and learned counsel for respondent number 4. It is submitted that the leading counsel for respondent number 4 is not able to appear today due to personal reasons and adjournment has been prayed for. Yes, then Mr.
And Ratan.
N. Ratan, learned additional AG for respondents number 1, 2, 3, and 5 is present.
And one submission from my side may kindly be recorded that this date was fixed in the presence of both the council and with the consent of both the parties.
Mr. D. Mazumdar, learned senior counsel, has submitted that this matter was fixed for today in the presence of the learned counsel, Mr. R.K.
R.K. Fukan.
No, Mr. Raka Bijoy. Isn't it who's
Yes,
absent in the last court date? And that in spite of being aware of the fixed date, he is still absent today. This court has noted, we have taken note of the submission made by the learned senior counsel, and the matter is adjourned to, give us the date.
Eight, DB is available on 2 occasions in a week, manner, Tuesday and Thursday.
Different bench, different bench,
Eight is the Thursday.
Thursday.
8th is the Thursday.
Thursday.
Thursday, 8th of August.
8th of August.
Okay, okay, 8 August, 2024. It may be noted that
Otherwise, I could have done my part, but this bench is only for this week.
if adjournment is sought again by the learned counsels for the respondents, this court shall pass appropriate orders. Maybe we'll impose costs, let's see. Anyway, in the next date, list on 8/8/2024. Yes.
Madam, may kindly mention that endeavor shall be made for disposal. Indeed.
So on which an endeavor shall be made for disposal of the instant writ appeal. Yes. Yes.
Briefly or less.
I don't know.
He is there.
But this is an appeal against conviction, isn't it?
Yes, Lord.
So how many days delay?
82 days
42.
delay.
42 days.
82 days.
82, yes,
82.
82 days. Will allow, condone, isn't it? It's against a conviction.
Yes, sir, it's a pretty appeal. It may be allowed.
Allow, dispose it. Third, Mr.
Jeet Alo, Lordship.
D. Taruk, learned counsel for the applicant. This is an application filed under section 5 of the Limitation Act for condoning the delay of 82 days in preferring an appeal against the judgment and order dated 8/02/2024, passed by the Sessions Judge, bracket, Bomdila, West Kameng, in connection with session case number 19/2023 under section 302 of the IPC. Now, when did you file this?
Lordship.
Okay, new law is not required right now, huh? Convicting the convict under section 302 of the IPC, wherein he was sentenced to life imprisonment and to pay an amount of rupees 10,000. Okay, no ID. Okay. No ID,
Pardon, Lordship.
no in default, no default clause,
No default.
Okay. Rupees 10,000 only. Issue notice to the state respondents, Mr. So-and-so, learned additional BP, accepts notice on behalf of the state respondent. See, ID is there, default clause is there,
Pardon,
Uh,
right.
10,000,
82.
ID, SI, 2 months.
Okay.
Yes, Mr. So-and-so accepts notice on behalf of the state respondents. The learned counsel for the applicant submits that the delay of 82 days in filing the instant appeal is mainly due to the fact that time was taken for obtaining necessary copies of and documents and for engaging the counsel to represent the convict. Mr. So-and-so, learned additional AG has not raised any objection to the condonation of 82 days in preferring the appeal against the judgment and order dated 28/02/2024. We have considered and perused the reasons given for the delay of 82 days in preferring the appeal, and we are satisfied with the reasons and the explanation given by the learned counsel for the applicant. Accordingly, the delay of 82 days in preferring the instant appeal against the judgment and order dated 28/02/2024, passed by the learned session judge, Bombilla, West Kamling, in connection with session case number 19/2023 under section 302 IPC is condoned. Accordingly, IA number 66 of 2024 stands allowed and disclosed.
Obliged.
Yes. Now, on the disposal, the criminal appeal.
65.
66, I think.
65, my fault.
Yeah, it's given 66.
Was this 65?
So
What is
registry,
this?
just check.
What-
IA is numbered 66 here.
Check up.
Anyway, 66 or 65, the registry will check.
She'll keep it.
So 66. IA 66 is for condonation of delay, but in the office.
Suspension. That is for suspension.
Which one?
The 66.
So make sure it's correct. Okay, here it's given the 66.
Everywhere it is.
Oh, oh.
Make it, check it up and tell them.
So delay is condoned, so the application for condonation of delay with the IA number, you please check, is condoned. Now, in the main criminal appeal. On the disposal of the application for condonation of delay, heard Mr. So-and-so, learned counsel for the, you're also for counsel for the appellant?
Yes, Lord.
For the appellant. Then what? Tell me.
Lordship, basically, we are disputing the judgment. The chain of, because it is convicted, he is convicted under circumstantial evidence. The chain that is required for convicting him under the circumstantial evidence was not complete. There were lapses in the investigation and the evidence that were taken by the learned trial court, Lordship. So we are disputing those lapses in averting that the chain of circumstances that should have been there for convicting someone under circumstantial evidence, especially in a heinous offense like 302, wherein the burden of proof is much higher than other offenses, Lordship, has not been maintained by the learned trial court, Lordship.
Yes, heard Mr. So-and-so, learned counsel for the appellant. The learned counsel for the appellant submits that the instant appeal against the judgment and order dated 28/02/2024, passed by the learned, again, session judge, copy paste the whole thing, okay, from the so-and-so, is liable to be set aside since the learned trial court had failed to appreciate the evidence, prosecution evidence correctly, and that the prosecution evidence is purely circumstantial evidence.
Yes, Lord.
Okay, and the evidence does not establish the chain, does not establish or complete the chain of circumstances. And therefore, the learned trial court had erred in convicting the appellant under section 302 IPC. Appeal is admitted.
Notice has to be issued to
Yes, issue notice
respondent.
to the respondents.
Number two.
No, 302, number 2 is required, or I don't think so, respondent. Have you made the respondent
Yes.
number 2?
We-
You have made.
We have made a party.
If it's
Yes,
so, it is mandatory.
Yes,
If it's
now in every
202,
criminal trial, it's now become a participatory right of the
Where?
victim and legal guardians or who you authorized. It's one Jagjit Singh Supreme Court cases. There,
Anyway, you have made respondent number 2 a party,
Yes.
then we'll have to issue notice. Okay, but I don't think it's mandatory. It's POXO, it is
yes,
mandatory.
of course,
Oh,
POXO,
yeah.
as well as in other criminal trials.
No, anyways, they've made a party, we'll issue notice. If respondent number 2 has not been made a party, I don't think it would be required. Okay, for 302. Anyways, since he's made them a party, we'll issue notice in this case. Okay. Mr. So-and-so, learned additional PP accepts notice on behalf of the state respondents number 1. Notice is to be issued to respondent number 2 through registered post with AD. Within 3 days, returnable by 3 weeks. List after 3 weeks. Meanwhile, LCR is to be called for.
Obliged.
Much obliged.
Just find out, where is this judgment that says that for 302 in all criminal cases, they have to be made a party. Okay, it will be interesting.
May I
Yes.
please, Lordship? Lordship, I will given a week time here, Lordship, in this case, Lordship. Earlier, Mr. Learned AAG was appearing in this case, Lordship. For some personal difficulties, he is not in position. I'll be doing the case, Lordship.
Yes, who's for the?
I'm for petitioner, madam. Petitioner, madam. Appellant.
You're for the appellant?
Yes, appellant.
You're the leading counsel?
No, madam.
No, so you're going to pay for adjournment, isn't it?
Yes, madam.
And the submission made by the councils for both the parties, this matter is adjourned for 2 weeks,
Close, Lordship.
2 weeks. No, you just. Yes.
My lord, I am sorry, kindly accommodate me for 1 week.
Hmm.
I was preoccupied for 2-3 days. Yesterday, I was not in the court. So could not lay my hand on the brief.
Okay, so another adjournment. Okay, Mr. T.T. Tara, Learned Counsel for the appellant, has prayed for adjournment, which is not objected by the learned counsels for the respondents. In view of the above, list after 2 weeks? Yes, 2 weeks.
2 weeks.
You
Yes.
want a date?
No, my lord.
Make it 2 weeks on a
Yeah.
date fixed by the registrar.
Register. Great. Sir.
Obliged.
So only the filing is also with the.
This is an appeal by the state, madam.
Who is for it?
I think they are appearing to visit.
I'm for a sole respondent.
Yes.
Your Lordship must have noticed, the direction has been issued to grant regular stay to a contingency staff. And the learned single judge has applied the principle of equal pay for equal work. In my humble submission, madam, the judgment relied on Jagdeep Singh. That will not have any application to the facts of this case.
Hmm.
The other aspect, your lordships are aware, we have thousands of contingency staff. If this becomes a precedence, the financial burden will be in several crores. But facts are like this. In 1990, to be precise, 10th of October 1990, the petitioner, respondent number 1, was appointed as a skilled contingency staff, which your lordship will find at page 47.
Thereafter, from time, on occasions against leave vacancies, etc., she was allowed to function as a LDC.
Hmm.
Mainly, if your lordship has gone to Jagjit Singh, your lordship would straight away come to para 42. The principles laid down itself make it very clear. First, your lordship will have
Wait. Yes, so we're going to look at
your lordship may
the
first turn to
judgment first.
Jagjit Singh is at page 148, 2017 1 SSC 148. Your lordship may straight away turn to para 60 first. It is at page 224. Have my lord's got it. Having traversed the legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees, daily wage employees, ad hoc appointees, employees appointed on casual basis, contractual employees, and the like, the sole factor that requires our determination is whether the employees concerned before this court were rendering similar duties and responsibilities as were being discharged by regular employees holding the same corresponding posts. This exercise would require the application of the parameters of the principle of equal pay for equal work summarized by us in para 42. Now, if your lordship comes back to para 42, the parameters have been laid down in detail. And in my humble submission, the parameters laid down at 42.1, 42.3, 42.5, 42.6, and 42.8 have been entirely overlooked by the learned assembly. May I first take your lordship to 42.1? The onus of proof of parity in the duties and responsibilities of the subject post with the reference post under the principle of equal pay for equal work lies on the person who claims it. He who approaches the court has to establish that the subject post occupied by him requires him to discharge equal work of equal value as the reference post. Now 42.3, this further qualifies 42.1. The principle of equal pay for equal work applies to cases of unequal scales of pay based on no classification or irrational classification. For equal pay, the employees concerned with whom equation is sought should be performing work which, besides being functionally equal, should be of the same quality and sensitivity. Now 42.5, in determining equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that the duties of the two posts should be of equal sensitivity and also qualitatively similar. Differentiation of pay scales for posts with difference in degree of responsibility, reliability, and confidentiality would fall within the realm of valid classification, and therefore pay differentiation would be legitimate and permissible. The nature of work of the subject post should be the same and not less onerous than the reference post. Even the volume of work should be the same, and so also the level of responsibility. If these parameters are not met, parity cannot be claimed under the principle of equal pay for equal work. Now, 42.6 is very important. For placement in regular scale, the claimant has to be a regular appointee. The claimant should have been selected on the basis of a regular process of recruitment. An employee appointed on a temporary basis cannot claim to be placed in the regular pay scale. This, I think, clinches the issue. Here, obviously, there was no selection process. She did not come through the regular channel. In fact, we have a set of rules. If your lordships will permit me to place the rules, your lordships will straight away come to page 91. This is a set of rules for appointment as LDC. And if your lordship comes to the schedule which provides for the qualifications, experience, etc. Rule 2 says these rules shall apply to the post as specified in column 1 of the schedule annexed to the rules. Rule 3 says number of posts, etc. Also given in the schedule. Method of recruitment, again as per the schedule. So now if your lordship kindly turns to page 93, your lordship will find the schedule. First, your lordship will find there is a quota earmark. If your lordship at page 93 turns to the extreme right hand column, method of recruitment, your lordship will find 25% is meant for promotion from MTS through limited departmental competitive examination, 15% from skill contingency staff. So she would be entitled for a consideration under this 15% from skill contingency staff examination, 60% by direct recruitment through a competitive examination conducted by the Arunachal Pradesh Staff Selection Board on the basis of the merit adjust through the common examination scheme in the following subjects: general English 100 marks, general knowledge 100 marks, and elementary mathematics 100 marks. On the left hand side, the parameters and method is provided for the direct recruits. Your lordship will find in the extreme right, left hand column, educational and other qualifications required for direct recruits. And the lordship will find what are the requirements. Should be a class 12 pass, then typing speed test of 35 words per minute on computer, etc., etc. Then C, minimum 6 months diploma in computer application from a recognized board, etc., etc. Now, if your lordship turns the page to page 94, what are the parameters for the 25% to be promoted from MTS and 15% to be promoted from skill contingency? Your lordship will find at page 94. The reason I am placing this is Jagjit Singh also says that if there is a difference in qualifications, even then equal pay for equal work will have no application. And this is evident from the rules itself. At page 94, towards the bottom of the page, what is the requirement for this 15% to be promoted from skill contingency is given. Have my lords got that. Towards the bottom of the page of 94. 15% of the vacancies shall be filled up from amongst the skill contingency staff with minimum 12 years of continuous service as skill contingency in the department office and possess educational qualification of class 12 pass certificate from a recognized board or institution. And thereafter, your lordship will find that the requirement of typing speed and diploma in computers, etc., is not even there. So again, Jagjit Singh also makes that qualification. Para, I think 42 point. If I may take your lordship back to
Para 42.
42.8 of Jagjit Singh. If the qualifications for recruitment to the subject post vis-a-vis the reference post are different, it may be difficult to conclude that the duties and responsibilities of the posts are qualitatively similar or comparable. Now, we had filed an affidavit before the learned single judge, which your lordship will find at page 99 of the...
See, before you go ahead, but okay, the qualifications are different, but what about the duties? Under duties.
Duties, that is what I was immediately coming to. If your lordship will allow me to place the affidavit. We have filed an affidavit before the learned single judge, which your lordship will find at page 99. It's an additional affidavit that we have filed. There were, in fact, two specific queries posed by the learned single judge. And in response to those queries, we filed this affidavit. And your lordship will kindly peruse para 2 of that at page 100. That the twofold queries are, firstly, if the vacancies of LDC is available in the department to absorb the petitioner, and secondly, whether the quantity or quality of works performed by the contingency staff and regular LDC are same or not. At present, there is no vacant post of LDC available in the department, and even if vacancy arises, the same has to be filled up through the Arunachal Pradesh Staff Selection Board as per the prevailing recruitment rules. That is the answer to the first query. And the second query, the qualities and quantity of the works performed by the regular LDC and contingency staffs are different. The regular LDCs are assigned with a particular branches to handle the files and connected working thereon, whereas services of the contingency staffs are utilized for typing, receipt, dispatch, etc. in assistance to the regular LDC, MTC, and UDCs, and they are engaged for any residue works. We have very categorically put it on record that quantitatively and qualitatively the functions performed are different. And this aspect, you'll also find in the impugned judgment,
Was not reflected.
was not considered at all by the. In fact, if your lordships come to the impugned judgment, the lordship will find the judgment at page 14. And if your lordships turn to para 10, till para 9, the submissions are recorded. Page 19 of the memo of appeal, your lordship will find, up to para 9, the contentions are recorded. And para 10 onwards is the consideration. There were 2-4 prayers made in the writ petition. One was a prayer for regularization. And the second prayer was to, if not regularization, grant a regular scheme. The first consideration, the first prayer is considered from para 10, which we are not really concerned. That prayer was rejected at para 12. The prayer for regularization, page 20, your lordships will find, para 12. Under the aforesaid circumstances, this court deemed it not fit and proper to direct respondent authorities to regularize her service, else it would violate the right of the candidates who are senior to her and whose names are in serial number 1 to 6 of the seniority list. In view of the above discussion and finding, the first issue has to be answered in negative, and accordingly the same stands answered. Notwithstanding, it is provided that the respondent authority shall regularize her services when her turn will come as per the recruitment rules. With up to that, there is no problem. Now, para 13 onwards is the consideration for the second prayer. Now, coming to the second issue, I find that there is substance in the submission so advanced by Mr. So-and-so, the learned counsel for the petitioner, and the ratio laid down by Honorable Supreme Court in the case of Jagjit Singh also strengthened his submission. It is to be noted here that in the aforesaid case in para 42 of the 42, the Honorable Supreme Court has summarized the parameters for application with the principle of equal pay for equal work. It is held as under, and Jagjit Singh is quoted thereafter, and it continues up to page 24. And the consideration on the basis of the facts is from para 15. After quoting Jagjit Singh, para 15. Now, adverting to the facts here in this case, I find that it is the pleaded case of the petitioner that apart from the period indicated in Annexure B to B1 to B3, in her entire period of service, she has been discharging the duties which are assigned to regular LDC. The order dated so-and-so at page 41 of the petition, which is the Charter of Duties and Responsibilities in respect of officials posted under District Food and Civil Supply Office, indicates the duties assigned to the petitioner at serial number 8 and to one LDC, namely so-and-so, at serial number 9, while she was serving at 0. For better appreciation of the contention, it is reproduced herein below. Srimati Veena Devi, contingency staff, issue renewal of BPL, etc., ration card and correspondence, etc., typing work. Merely on the basis of this, the learned single judge proceeded further at para 16 and 17. Be it mentioned here that Annexure F is not disputed by the respondent authority. Thus, it appears that the onus of proof of parity in the duties and responsibilities of the subject post and the reference post under the principle of equal pay for equal work appears to be successfully discharged by the petitioner. There is no consideration of the specific stand taken by us in the additional appeal, which was on the basis of a specific query made by the learned single judge. Now, thus, Annexure F leaves no room for doubt that the petitioner has been discharging identical duties with that of the reference post, that is LDC, in the office of the respondent authority. The contention of the petitioner that she has been discharging the work of LDC in the office of the district so-and-so and subsequently at DRC office Tezpur since her joining has not been seriously disputed by the respondent authorities. Annexure C1, C2 and C3 and Annexure H series of the documents reveals that the petitioner is sincere and diligent. Also, it is also not in dispute that the petitioner has rendered 32 years service and she has been drawing less than half of the salary which the regular LDC have been drawing. Thus, I find no good reason as to why the principle of equal pay for equal work as enunciated in the case of Jagjit Singh and the ratio laid down therein will not be applicable to the facts of the case in hand. Though Mr. So-and-so, the learned senior government advocate submits that the ratio laid down in the case of Jagjit Singh is not applicable in the present case, the said submission left this court unimpressed. I find no good reason as to why the ratio will not be applicable in the case in hand. Under the facts and circumstances discussed herein above, this court is of the considered opinion that the ratio laid down in the case of Jagjit Singh and the principle of equal pay for equal work is squarely applicable in the case of the present petitioner. It is also to be mentioned here that in the case of Jagjit Singh, it has also been stated that there can be no doubt that the principle of equal pay for equal work would be applicable to all concerned temporary employees so as to vest them the right to claim wages at par with the minimum pay scale of regularly engaged government employees holding the same post. Thus, drawing premises from the principle of law, so enunciated in Jagjit Singh Supra, this court is inclined to answer the second issue, which has been framed in para number 8 in favor of the petitioner. Accordingly, by a mandamus of this court, the respondent authorities are directed to provide minimum of the scale of pay in the lowest grade of the LDC to the petitioner forthwith.
So let's see Annexure F.
But these are all documents from time to time
Huh.
that were.
Who has issued the document Annexure F? I think it's based on Annexure F, the nature of duties.
Yes.
That this court has come to that finding.
That you will
So who
find
issued that?
at 75.
Page 75.
Page 75.
So Annexure F is a order issued by the concerned authority, isn't it?
Yes,
District Food and Civil Officer.
ma'am.
So this is a distribution of work.
Distribution of work. And if your
So
lordship will
if you
kindly
look at
turn
the
to,
nature of a work, huh?
if your lordship will kindly turn to page 76, at serial number 8 is the respondent number 1 repetition.
Okay. Now let.
Issue
let us
renewal
look at-
BPL, AAY, so-and-so ration card and correspondence and typing work.
So let's
Merely,
look at the additional affidavit file. Your
merely
additional
because we
affidavit,
allotted her some typing work will not make it at par with the duties and responsibilities of
Okay,
regular.
so let's look at the additional affidavit which you had filed before the single judge.
That affidavit, your lordship will find at page 98. And we are saying that from time to time, some typing works are given, but there are various other responsibilities which are not at par.
Page
Right.
100. So
100
here
and one.
you explain the of contingency staff and the regular
The regular indices.
LDCs, isn't it?
Yes. 6 lines from.
Contingent staff is typing, receipt dispatch, etc.
Just read the people there.
Hmm.
6 lines from bottom. The regular LDCs are assigned,
The regular LDCs are particular branches to handle files.
connected with.
Okay, so files are handled here? No.
Yes.
No, files by serial number 8, not handled.
These are LDC, regular LDC.
Yes.
See the nature of them.
Renewal.
Issue renewal of APL or card and correspondence and issue of LOC typing.
Hmm.
And body
So
petition is equal
all
to
the same.
practically the same. That may be, that decision of the LOC.
See, if you come to page 76,
My lord.
okay, the nature of work at serial number 8 is the instant appellant. The petitioner, okay? And then she's the contingency staff. And if you look at serial number 9,
Yes,
that is a regular LDC. What is the difference in their work?
that is what we have explained in the additional affidavit. I cannot
What?
obviously go beyond the pleaded case.
But look
I cannot
the
at this
language
stage-
used, huh?
If
Issue renewal.
your lordship
So
will
they are
kindly,
doing the same nature of work.
we cannot this is a routine order that is being issued,
Hmm.
but the explanation as has been given in the affidavit, if your lordship will kindly come back to that.
Hmm.
If your lordship will come back to page
But
99.
your additional affidavit has to be based on some, order or notification issued by the government.
That is, your lordship is aware, many of the things in administration also are based on the practice that is followed.
Practice
For
that
all-
is followed, but obviously it's not followed in this case. If you look at page 76, the nature of the work.
Assuming for a moment,
Hmm.
assuming for a moment, there is some similarity of work, but there are other parameters laid down in the list. That is what is my contention. If your lordship comes back to Jagjit Singh, one of the things that it says is
Nature of work and then the qualification required for the
qualifications,
appointment.
then
Yeah.
whether the person concerned has come in through the regular channel.
Hmm.
What in my humble understanding, subject to correction, as I have understood Jagjit Singh, there are situations where people may have been appointed on a temporary basis,
Mhm.
but they have come after being regularly selected. And that temporary appointment is against the regular post. Here, by the very nomenclature, one can understand that these are purely contingent.
Contingent post.
What really will happen is, in fact, my lord, there is a judgment of the Supreme Court that also I am relying on. I'll come to that, my lord. But before that, my lord, may I read that entire page 99, if your lordship will come back to. Towards the middle of para 10, there is a sentence starting where we have answered the second query, page 100.
Okay.
Towards the middle of that paragraph, there is a sentence starting the qualities. Have my lords got it? Towards the right hand side, the qualities and quantity of the work. The qualities and quantity of the works performed by the regular LDC and contingency staffs are different. The regular LDCs are assigned with a particular branches to handle the files and connected work working thereon, whereas services of the contingency staff are utilized for typing, receipt dispatch, etc., in assistance to the regular LDCs, MTS and UDC, and they are engaged for any residue works that may arise in any sections of the department as per the demand of the job in the office. The services of the contingency staffs are taken in the nature of the works which are being performed by the MDS, LDC, and UDC, and their services are being taken in assistance of them. Therefore, there is no regular post for contingency staff in the department. They are called contingency staff whose services are being taken in any residue works that may arise in the department, particularly in the nature of works being performed by the MDS, LDC, and UDC. It be mentioned here that the petitioner is serving as skilled contingency staff, but not as LDC, and there is no post called contingency LDC in the department. If your lordship kindly comes back to the original appointment order, original engagement at page 47, we are not disputing the fact that on occasions when there have been temporary vacancies, let's say a leave vacancy, she has been assigned work.
Yes.
If your lordship kindly comes to page 47, this is the first order of engagement. Srimati Bina Devi so-and-so is hereby appointed as skill contingent paid staff at the rate of rupees so-and-so, only fixed per month with effect from so-and-so. Now, thereafter, next page itself, your lordship will find she was allowed to perform some functions of LDC against a temporary vacancy for 60 days. But again, then there was a litigation when there was, she had filed a petition. There was some direction issued by the learned single judge, but reversed by the division bench. Pursuant to that,
What concerning what?
she had claimed regularization.
Okay.
She had relied on a circular. If your lordship wants to peruse that judgment, your lordship will find it on page 61. And the operative portion of the judgment is at page 66.
That is a different issue, isn't it? Claiming
That's a-
regularization.
Claim was for regularization.
Which was not
Same issue.
allowed, huh?
So the learned single judge had issued a direction for consideration on the basis of a particular circular. That was reversed by the division. Page 66, your lordship will find at para 6, having regard to the aforesaid factual situation and upon hearing the learned counsel for the parties and on perusal of the materials of record, the court intends to pass the following direction. That the respondents number 1 and 2, particularly the respondent number 2, shall consider the case of the petitioner in accordance with law and in the light of the aforesaid discussions and existing circulars as expeditiously as possible, preferably within a period of 3 months from the date of receipt of the certified copy. Now, against this, the state went up in appeal and it was reversed. Your lordship will find the operative portion of the division bench judgment at page 74. Page 74. Having regard to the above discussions, we are of the view that interference to the impugned judgment and order dated 31/5/2005 passed by the learned single judge is called for. Accordingly, the impugned judgment and order dated so and so is hereby set aside and the writ appeal is allowed. And a direction was given, an observation was made that
So
we may consider regularization.
That paragraph, huh?
We may consider, however, the disposal of the writ appeal shall not be a bar to the concerned authorities to consider the case of the writ petitioner for regular appointment to the post of LDC in accordance with the relevant rules. That we have never disputed. The only problem is there are 6 persons who are senior than the petitioner, which will be, therefore, in terms of the rules, as and when her turn comes, she'll definitely get the consideration. But the problem is,
Regularization. Same.
That's not an issue.
there is one judgment I'm relying on. It's 2022-4, volume 4 SCC 193. This is for the proposition, my lords, that your lordships, while exercising powers of judicial review, we will not pass orders which has a financial implication on the state. Because this has a cascading effect. Now, if this becomes a precedence, we will be compelled to pay to thousands of contingency staffs that are working under the government in various departments. Para 28. Para 28 at page 204. As per the settled proposition of law, the court should refrain from interfering with the policy decision which might have a cascading effect and having financial implications. Whether to grant certain benefits to the employees or not should be left to the expert body and undertakings, and the court cannot interfere lightly. Granting of certain benefits may result in a cascading effect, having adverse financial consequences. So this is the paragraph that I am relying on. The present case is a case where it has all possibilities of having a cascading effect. And we are not really what one can call a risk state. We have our financial constraints.
Contingent LDCs and regular LDCs. That's the main thing, the nature of their work.
True.
Yes.
And on the principle of equal pay for equal work, the learned single judge relied only on Jagjeet Singh. There's one judgment I would like to rely on. Here, almost similar was the contention, but I'm relying on paragraphs. The citation is 2006 9 SCC 321.
Para?
I'm relying on paragraphs 22 and 23. Here also the apex court discussed all the judgments on equal pay for equal work. Para 22. One other fact, have my notes. It's at page 336. One other fact which must be noted is that the civil appeals number so and so do not deal with casual or daily rated workers. These are cases of persons employed on contract. To such persons, the principle of equal pay for equal work has no application. The full bench judgment dealt with only daily rated and casual workers. Where a person is employed under a contract, it is the contract which will govern the terms and conditions of service. In state of Haryana versus so and so, persons employed on contract basis claimed equal pay as regular workers on the footing that their posts were interchangeable. It was held that these persons had no right to the regular posts until they are duly selected and appointed. It was held that they were not entitled to the same pay as regular employees by claiming that they are discharging the same duties. It was held that the very object of selection is to test the eligibility and then to make appointment in accordance with the rules. It was held that the respondents had not been recruited in accordance with the rules prescribed for recruitment. In Union of India versus so and so, the question was whether commission bearers, vendors are entitled to the same salary as regular employees. It was held that their appointment and mode of selection, their qualifications cannot be compared with regular employees. It was held that by their very nature of employment, they cannot be equated with regular employees. It was held that recruitment rules and service conditions do not apply to such persons. It was held that their responsibilities cannot be equated with those of regular employees. Thus, it is clear that persons employed on contract cannot claim equal pay on the basis of equal pay for equal work. Faced with this situation, it was submitted that all these persons were in fact claiming that their respective appointments were regular appointments by the regular process of appointment, but that instead of giving regular appointments, they were appointed on contract with the intention of not paying them regular salary. It was admitted that the petitions may be badly drafted and such a contention was not put forth specifically. The High Court has disposed of these petitions also on the footing that the principle of equal pay for equal work apply. We therefore set aside the impugned orders, etc. Basically, one of the things, as I was pointing out, one may term them as temporary employees, but if they have come through a regular process, some semblance of selection. Otherwise, what would essentially happen is Articles 14 and 16 get violated of the persons who did not receive any consideration. So therefore, that is one of the pertinent aspects while taking note of the principle of equal pay for equal work. And in fact, your lordships are aware, after Jagjit Singh has been distinguished. Your lordship would be aware of the Madhya Pradesh case, where a person claimed that after retirement, he staked a claim. He was, if I recall correctly, he was called some chief officer of forest department. Post-retirement, he said that now this is a post which has been regularly encadred. So fix my salary in that post since I served in that post. And based on that, you fix my pension. The Supreme Court has said that no, you cannot because you did not face a regular selection. And Jagjit Singh, the High Court had passed a judgment based on Jagjit Singh. The Supreme Court said no, Jagjit Singh cannot be stretched to this extent. Unfortunately, I'm not carrying the judgment today. But there Jagjit Singh was considered. I should be able to.
It would be good if you can have the judgment, huh? No. Anyways, we'll listen to the respondent also. Yes.
That is my submission before your lordship.
Then we can hear the counsel for the respondent.
Yes, Lordship. Lordship, first of all, I would like to say, Lordship, the petitioner, respondent, the writ petitioner is qualified to hold the post of grade 3 LDC, Lordship. have already stated in the petition. Secondly, regarding Lordship, there is Jagjit Singh's judgment, Lordship. I would like to take Lordships to paragraph 57, Lordship. 56,
Page?
page 222, Lordship.
Honor, Lordship, that was the Jagjit Singh request, 2017.
So you're taking us to the judgment.
Yes, Lordship, to the Jagjit State of
Huh.
Punjab,
Okay, para
paragraph 56, Lordship. Page
56.
222.
Yes.
After discussing Lordship, now the Supreme Court held, Lordship, we shall now deal with the claim of the temporary employees before this court. Now, we are all temporary employees, Lord. Respondent is a temporary employee. And paragraph 57, the court said, Lordship, there is no room for any doubt that principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all the courts in India under Article 141 of the Constitution of India. The parameters of the principle have been summarized as in paragraph 42 here and above. The principle of equal pay for equal work has also been extended to temporary employees, differently described as work charge, daily wage, casual, ad hoc, contextual, and the like. The legal position relating to temporary employees has been summarized by us in paragraph 44 here and above. Now, I'd like to take your Lordship to paragraph 44, Lordship. 44 at page 209. May I read it?
Yes.
We shall first outline the conclusion drawn in cases where a claim for pay parity raised at the hands of the temporary employees concerned was accepted by this court by applying the principle of equal pay for equal work with reference to regular employees. 44.1, Lordship. This court examined a claim for pay parity raised by temporary employees for wages equal to those being disbursed to regular employees. The prayer was accepted. The action of not paying the same wage despite the work being same was considered as violative of Article 14 of the Constitution. It was held that action amounted to exploitation in a welfare state committed to a social pattern of society. Then again, Lordship, 44.2, Lordship, this court held that right of equal wages claimed by temporary employee emerged inter alia under Article 39 of the Constitution. The principle of equal pay for equal work was again applied when subject employee appointed on temporary basis and the reference employee was born on permanent establishment. The temporary employee was held entitled to wage drawn to an employee on regular establishment. In this judgment, this court took note of the fact that above provision affirmed by the Constitution bench of this court in D.S. Nakara's case, Lordship. Then again, Lordship, regarding the manner of selection and in making, there is no difference. At paragraph 44.3, Lordship, in Bhagavanda's case, this court recorded that in a claim for equal wages, the duration for which an employee would remain or had remained engaged would not make any difference. So also manner of selection and appointment would make no difference. And therefore, whether selection was made on the basis of open competition or unlimited to a cluster of villages was considered inconsequential insofar as the applicability of the principle is concerned. And likewise, whether appointment was for a fixed limited duration, 6 months or 1 year, for an unlimited duration, was also considered inconsequential insofar as the applicability of the principle of equal pay for equal work is concerned. It was held that claim for equal pay for equal wages should be sustainable where an employee is required to discharge similar duties and responsibilities as regular employees. An employee concerned possesses the qualification prescribed for the post. Here in my case, I am possessing the requisite qualification to hold the post of LDA. In the above case, this court rejected the contention advanced on behalf of the government that plea of equal wages to the employee in question was not sustainable because the employee concerned was engaged in a temporary scheme against posts which are sanctioned on year-to-year basis. All the paragraph 44 is lordship favors in respect of the respondent lordship. And regarding the judgment which my Advocate General has referred, lordship, that is 2006-9 SEC 321, also discussed in this case, lordship, in Jagjit Singh's case in lordship, in paragraph 51.2 at page 219, lordship. Even after considering this, the Supreme Court allows lordship.
Page number?
Page number 219, lordship.
Para?
Paragraph 51.2.
First, I don't think we are on the same page. Okay, wait.
219, lordship.
Para?
Paragraph 51.2.
Yes.
Even in the case under reference state of Punjab versus Surjit Singh, this court accepted the principle of equal pay for equal work as applicable to temporary employees by requiring the state to examine the claim of the respondents for pay parity by appointing an expert committee. The expert committee was required to determine whether respondents satisfied the condition stipulated in different judgment of this court, including state of Punjab versus Chiranjit Singh, the case which the Advocate General has referred, lordship, wherein this court had acceded to the proposition that daily wage who were rendering the same duties and responsibilities as regular employees would be entitled to minimum wage payable to regular employee, and had therefore remanded the matter back to High Court for fresh adjudication. The paragraph 38 lordship quoted, and then lordship 51.3. For all the above reasons, we are of the view that claim of temporary employees for minimum wages on at a par with regular engaged government employee cannot be declined on the basis of judgment of the state of Punjab versus Surjit Singh, lordship. Even after going through that, lordship, the Supreme Court clearly says you cannot decline, lordship, on the ground, on that ground, lordship. So my humble submission, lordship, petitioner is discharging the same duties and responsibility as that of LDC, lordship, and so, lordship, under the principle of equal pay and equal work, entitled the minimum of the pay scale of LDC, as Learned Single judge has rightly held, passed the order, lordship, and also in view of the judgment in Jagjit Singh's case, lordship. That's my humble submission. So that this writ appeal should be dismissed. And Supreme Court, lordship, has categorically said, in not only in Jagjit, in other cases also, lordship, and not giving the minimum scale of pay for equal work amounts to exploitation of service, lordship. And being a, lordship, a welfare state and a model employer, they should grant that.
I think we need to ponder on this. I think there is a lot of there's no topic. We need to create. But then, you are trying to read, you can send the judgments, you can see what's the-
That's one quick thing. The lordships will kindly peruse the pleadings, the factual foundation on the basis, because 42.1 of Jagjit Singh puts the onus of proof absolutely on the person claiming. Factually, what is the narration? This itself goes to show that he himself, now page 36 is his pleaded case on facts, para 3.
36.
Page 36 of the memo of appeal, your lordship will find the factual foundation based on which. This paragraph itself goes to show that she was, even when she filed the writ petition, she was aware that it was only on occasions, intermittently, that she was allowed to perform functions at par with that of LDC. Rest of the time, it was whatever manner in which services were required. That is how the services were taken. And that is the whole idea behind contingency stuff. And the other vital aspect, which perhaps needs to be taken note of,
She was in zero. Then after she was transferred to the deputy resident commissioner in Facebook. The nature of work that she was doing there, that unfortunately is not on.
So I think that
Page-
aspect.
page 77 on it.
Oh.
77, 78. Can I just-
Yes, please.
Mr.
yeah,
Chaudhary,
Observation.
the nature of works, at least when she was in zero, she was doing some intermittently or regularly intermittently, she was an LDC. She was engaged, and this page 75, 76 also shows that she was doing the nature work responsibility. That is a different concept, but the nature of works were same. But she was in 2014 transferred to the office of DRC in Tezpur. What is the nature of work after that she is doing? That is not there.
this is, it's clear from this itself. In the interest of public service, the following contingencies are.
No, I got it. After that, what is she doing there? That is not on record.
As contingency. A contingency staff,
Can be
even
he
in
gets
my
a
office in
MD.
Guwahati,
MTC. He can be an MTS, he can be a UDC, he can be a LDC, he
As
can
and
be
when-
anything.
as and when.
But what is the
It's-
pleaded material after 2014?
Nothing.
Yes, Mr. Sinha, after
Lordship,
2014, what
After
is the material?
2014, Lordship, I am at Tezpur issuing inner line permit, working as like LDC also. The work of
No.
work of nature is like
Where is that material?
Where's that?
Where is that material on record?
on record. It's not there, Lordship.
Then,
So we have to see the nature of works.
that has to know. That is not there, so that aspect has to be taken into consideration. Romantic facts.
So basically now the issue today, your ground for setting aside the judgment and order of the learned trial, a single judge,
Lordship.
is that it is based on the nature of work performed.
Lordship.
There are multiple parameters laid down in.
Single judge.
So one is the main is the nature of work.
Not.
That's
only
what you're
nature of
hopping
work
on.
By itself will not be sufficient.
Hmm.
So what I am,
Uh,
my submission is
The
that
qualification required, that is
42.1
different.
42.1 of Jagjit Singh,
uh,
42.3 of Jagjit Singh,
Yes.
42.5 of Jagjit Singh, 42.6 of Jagjit
Hmm.
Singh, and 42.8 of Jagjit Singh are not fulfilled in this case.
Responsibility not taken into account of.
And sensitivity
Sensitivity not taken into account.
and qualification.
So that all comes
Qualification,
within
we will not.
that comes
The
within the.
nature of the engagement.
Yes.
That also we will not go because the paragraph 60,
Yes.
at least she has pleaded, and your rules also require class 12 pass. She has pleaded that she has that qualification.
Class 12, yes. But the reason I pointed out the rules was, even when the rulemaking authority framed the rules, they were conscious of the fact that this is a extra benefit that we are conferring. Even if they do not have the typing speed, even if they do not have the diploma, we will still consider. Which goes to show that she does not have the diploma, she does not have the typing speed. And it is nowhere pleaded that she fulfills those criteria. So
But what is the nature of work for the last 10 years?
that is not
From 2014, that is not.
that onus has not been fulfilled. 42.1 again comes into play. And in fact, I have just been able to lay my hands on a judgment. I hope this is the one. My junior has sent it.
What is the point in this?
This is the case where after Jagjeet Singh, as was expected, a series of cases started coming that we are temporary workers, we also should be given. So ultimately, Supreme Court had to clarify. Here, what it has categorically held is equal pay for equal work is not a right. It is not a fundamental right. It is only when all the parameters laid down in 42 point, para 42 of Jagjeet Singh are fulfilled, only then the principle comes into play.
All, not bits and pieces. Okay, yes, citation.
I will quickly, I haven't read the whole judgment, unfortunately, but I'll have to give the citation. It's 2022, volume 13, SCC 320.
2022.
13 SCC 320. What because I was back of my mind, I remembered seeing this judgment, and I'll just quickly read out. Yes, para 17, the last sentence. This is how it reads. As held in the state of Haryana versus Haryana Civil Secretariat Personal Staff so and so, equal pay for equal work is not a fundamental right vested in any employer, though it is a constitutional goal to be achieved by the government. So, this is by way of a directive principle that and judicially evolved over a period of time. So, therefore, Jagjeet Singh is very clear that 42, the parameters have been very clearly laid down. And it's a very difficult burden to be discharged, which I fully appreciate. And as has rightly followed from your lordship. 2014 order itself makes it very clear that it is contingency staff. What is the nature of the duties? To what extent it is at par with the LDC? Para 8.
That's why.
In fact, well, the minor justice Nayar's query seems to have been appeared by the petitioner himself. Page 40. Para 8. That your humble petitioners beg to state that as per order so and so, dated 13/11/2014, the present petitioner is transferred in the interest of public service from so and so 0 to DRC office Tezpur. And since then, the petitioner is discharging her duty under the establishment of so and so as skilled contingent.
The issue has been answered. Anyways, I think then we make it a series. We will consider all your submissions, materials. Okay. Because we were in two minds, whether justice would be done if we refer the matter back to the learned single judge to consider the nature of duties within the period, okay, from 2015 onwards. 14 onwards, okay, because it appeared that that was not on record. Okay, to see the nature of duties. We were discussing on that issue, whether it would be appropriate to refer the matter back. But here you have pointed out that the nature of duties has been explained in para 8. When we asked the learned counsel for the respondent, he said it is not on record. But in the petition itself,
Yes.
it was already mentioned.
And,
So it
and
might
that is
not
what
be
we are saying in the
appropriate.
additional affidavit. Exactly what we are saying in the additional affidavit. That there is
But,
a qualitative difference between the nature of the duties performed by the LDC and contingent staff. Because your lordship will kindly note one thing. In the state of Arunachal Pradesh, as a matter of policy, contingency staff are being engaged. Policy. So the moment your lordship upholds this judgment, what in essence happens indirectly? This is an incidental effect. The very policy of the state of Arunachal Pradesh of engaging contingency staff will be wiped out. So all will have to be given. The very concept of contingency staff will have to be wiped. So that is why I said it has a cascading effect.
Case by case, because the nature of duties again would be different. Maybe not all contingency staff will be doing the same work as this thing, okay? But then there was one hot in process, that is supposing we remanded back the matter for consideration of the learned single judge to reflect upon your additional affidavit, which was not at all discussed by the learned single judge.
But that is supported by his para 8 now.
So basically remanding it back, they're just passing on the buck and then, you know, waste of time maybe. So I think we'll make it a CAB. I think it will be more appropriate, okay, instead of sending it back. We'll dispose of the, yes. Then we'll have, but get a CAB, give it some time, you'll upon the points. Heard Mr. I, Chowdhury, learned AG for the state appellants, along with Mr.
SK Singh.
SK Sinha, learned counsel for the respondent. Okay. Hearing is complete. Matter out for judgment.
Deeply applied.
And matter was transferred here. So for this item, my lord, I had to step back. Lord. Matter relates to NBW was issued, my lord. At any moment, he may be, my lord, arrested. He's a government employee.
Okay.
I'm extremely sorry, my lord, because permission was sought for Friday. Permission was granted for Monday. Yesterday, it could not have been listed. So I had to step back here, my lord, and make a mention today.
Okay, list it later. Maybe for tomorrow.
Tomorrow, my lord.
Today, let's see if time will permit. We have a lot of cases.
Lord, if time permits, otherwise, my lord, I would have to again step back here today.
So if time permits,
My
we'll
lord,
see.
Lord, kindly consider.
If time
And I'm an
permits.
outstation advocate, my lord.
So if time permits,
My lord.
because there's a
My lord.
long process
My
for the files to be ready. Yes.
May I, your lordship?
Yeah. If time permits.
May I, your lordship? Lordship, I beg to mention item number 9, your lordship. This is an admission column. We have not filed our counter affidavit. So, your lordship, some more time may be needed, your lordship.
Yes, so let's see. Those will come up, isn't it? All those matters, many of them will be playing for time for filing of the counter, etc. So unless it is for supplementary hearing or cases that will take long, rest you come as per the listing list, isn't it? Otherwise, I don't know. What, the queue is for what? Simple adjournments? Okay.
May I
Lordship, I beg to mention item number, my lord. This 18, your lordship. 17 and 18.
These
I
are
have the-
for orders.
Yes,
What
I
is-
have the instruction to withdraw this matter, my lord.
What is the IA about?
My lord,
IA is for
IA is
implement.
for implement of the applicant in the connected my lord,
Okay.
petitions. 18, my lord.
WPC is for?
WPC is, we have filed this WPC against the LPC, cancellation of LPC.
So it's
No,
for withdrawal of the IA
no,
or the WPC?
WPC.
Okay,
Now,
heard
I
Mr.
become infractious in
Hmm.
person to
Okay, heard Mr.
SK Deori.
SK, the learned counsel for the petitioner, who submits that the instant case has become infructuous and prayed for withdrawal of the instant writ petition. Accordingly, the writ petition stands disposed of on withdrawal, huh? Yes.
IA is infractuous, otherwise, if
That's what I asked, no,
Okay.
is it the IA or the WPC?
WPC. WPC is not infractuous, but I have the instruction to withdraw. Read petition.
Okay, submits that he has received instructions for withdrawing the instant writ petition. In view of the above, the instant writ petition stands withdrawn. And accordingly, the IA, connected IA, being infructuous, is also disposed of.
Applies.
If it may please your lordship, I beg to mention item number 26 of supplementary hearing. My lord, we have for the
Supplementary
respondent,
hearing, huh?
we have for the respondent hearing, your lordship. The conducting counsel, Mr. Panging, has some difficulty today. Can the matter be listed on 7th of August, your lordship?
Who's for the,
Mr. Tara is appearing on behalf of the petitioner.
not objected?
No, we have
Yes.
informed him.
Mention is made on behalf of Mr.
D. Panging.
D. Paging, learned counsel for the respondent for adjournment of the matter, which is not objected. Adjournment of the matter with the consent of the appellants. In view of the above, as prayed for, list on
7th August, your
okay,
lordship.
7th August. Hmm.
My lord, I also beg to mention another item, your lordship, item number 30.
30.
Yes, your lordship. My lord, the counsel for the respondents are not here today, your lordship. Can the
You're
matter
for the, you're for the,
for petitioner, your lordship?
okay,
May I pray the matter may be listed after 2 weeks?
on the prayer made by the learned counsel for the petitioner, matters adjourned for 2 weeks. List after 2 weeks.
Much obliged.
For 2 weeks on date fixed by the registry. Yes.
May I please, your lordship?
Yes,
I beg to mention item number 29.
29.
Yes, your lordship.
Oh.
We had also concerned with other parties. Since leading counsel of this case, Mr. K. Tama, was supposed to reach yesterday, but because of due to landsliding and road blockage on the way of 0 to Itanagar, he could not. So matter may be listed after 3 weeks.
Okay, mention is made on behalf of Mr. K. Tama, leading counsel in the instant, leading counsel for the
And your
petitioner
lordship, interim may be continued.
for adjournment of the matter.
And for the victim,
Which is not objected by the counsels for the respondents. In view of the above, this is matter after 2 weeks, is it?
3 weeks.
Or 3 weeks on the dates fixed by the registry. Meanwhile, interim order passed earlier shall continue till the next date.
Highly obliged.
Yes,
May I send, madam? I beg to mention item number 6, my lord. Here, my lord, I pray some time, my lord, to file reply to the epidemic in
no,
opposition.
that will come, yes, admission stage. Any other supplementary hearing matter? Are we going to have hearing today, huh?
I beg to mention item number 4. As the conducting counsel is out of station, Mr. Aibam.
Okay, we'll note that when this thing. Any other supplementary hearing matter? Okay,
May your worship, I beg to mention item number 14. I am appearing on behalf of AK Singh, conducting counsel. He is not able to appear before this honorable court due to some health issue today.
We don't seem to be understanding. 14 adjourned. Yes, any supplementary hearing?
Deeply obliged.
Well, this matter has been wrongly listed before this bench, my lord.
Hmm.
It ought to have been listed before the division bench. The order is passed by the division bench, my
Okay,
lord.
so.
Direct the registry
Yes,
to list it
heard
before the
Mr.
division
T.
bench.
T. Tara, learned counsel for the petitioner who submits that the instant matter is to be listed before the division bench. Accordingly, registry to do the needful.
Much obliged.
May it please your lordship. My lord, matter relates to cancellation of GST registration, my lord. Petitioner's GST registration matter relates to cancellation of GST registration, my lord. Petitioner's GST registration was cancelled, my lord, because of default in filing the returns, my lord. Lordship will find the order at page, my lord, 29. Subsequently, my petitioner has complied with all the defaults and he has updated all his pending returns, my lord. Now he is seeking revocation of the cancellation, my lord. Now, my lord, the coordinate bench of this honorable court has passed similar orders, which your lordship will find at page 45, my lord. The orders were passed, my lord, subject to payment of pending dues and filing of returns, my lord. Similar order starts from page 45, my lord. Operating part is at page 47, my lord. I'm praying for similar relief, my lord.
Yes, so you're saying this is a covered matter.
My lord.
Anyone appearing for the respondents?
My lord, I'm for the respondent, all respondents, my lord. PhD.
So you're the standing counsel for GST.
My lord, by virtue of the DSCI, my lord, I'm appealing.
Okay. So you're saying this is a covered matter where his
Yes, my lord,
registration has been
since
cancelled?
The copy is, my lord, annexed. Page number 48, my lord.
Oh.
Same order maybe.
So at the motion stage itself, can we dispose of?
My lord, in that case, my lord, may I pray then, my lord, I may be allowed to take instruction, my lord.
Okay. Because if it is covered and it's the same, then we can say it's a covered matter and dispose of at the motion stage itself.
My lord,
Isn't
please
it?
take- Yes, my lord, my lord. At least, my lord, I'll take instruction in the meantime.
You need instructions. What instructions? If it's covered.
Whether any
So
further,
have you seen the facts?
my lord, the initiation or the proceeding has been taken or not, my lord, in view of, my lord, or the path.
Okay, you need to see whether it's a covered case or not.
Madam.
Is it? Okay. Yes, heard, Mr.
Yes, Mr. My lord.
Will you show notice?
My lord, it can fix on 29 for instructions, my lord, for motion only on next Monday, if lordship allows.
No, we will, they should let him, this thing, will issue notice, let him accept the notice copy and then we'll see, isn't it?
Yes, ma'am.
Heard, Mr. So-and-so, Lieutenant Counsel for the petitioner, who has filed the instant petition. For the issuance of the appropriate order. Slash writ under Article 226 to the respondents. Wherein the petitioner was engaged in the business of execution of works contract under the name and style of MS&R Enterprises, having its registered office at A-Sector Filu, 0 district. No, 0, then comma, district lower Suband Shiri, Arunachal and registered under the provisions of Central Goods and Services Act 2017, bearing registration number 12 capital B, capital R, capital N, capital P, 6441 RI0. Is it? That a show cause notice was issued to the petitioner and his registration was cancelled due to failure to file statutory returns under GST. The petitioner then after filing returns, filed an application for revocation filed a revocation application, which was not allowed. The instant petitioner has then approached this court due to the cancellation of the GST registration. Notice be issued to the respondents. Mr. M. Kato, learned so and so, accepts notice on behalf of the respondents. No need to issue formal notice. The learned counsel for the petitioner submits that this is a covered matter, citing the decision of the coordinate bench of this court in
Page 45, madam. Page 45.
yes, and WPC 6232/2022 dated 29/9/2022, comma WPC 4063/2022 dated 30/09/2022 and WPC 7018/2023 dated 08/12/2023. Should start. The learned, Mr. Katu, learned counsel for the respondent, has prayed for time to get instructions whether the instant writ petition is a covered matter as submitted by the learned counsel for the petitioner. In view of the above list.
On 29th, Lordship allows next Monday, 29th.
Okay, list this matter on 29/7/2024.
Deeply obliged.
Yes.
If I may.
Now, the office note dated 22/07 says that affidavit in reply not yet filed.
Right. No, should we have filed a dividend?
Have you filed the affidavit in reply to the affidavit in opposition filed by the respondents?
We have a copy. I believe there is a misunderstanding.
No, madam, we have not received reply, ma'am.
We'll file in that case.
Mr. So-and-so, learned counsel for the petitioner is present along with Miss so-and-so, learned government advocate.
Yes, ma'am. For respondent 4, 5, and 10.
For the state respondents number 4, 5, and 10. As per the office note dated 22/07/2024, the learned counsel for the petitioner is to file the affidavit in reply. It is submitted that the affidavit in reply has been filed by the petitioner. However, on perusal of the documents available on the court, it is seen that the said affidavit in reply is not available. The learned counsel for the petitioner is to take steps to ensure that the affidavit in reply is available in the record. Please find out. It's not here. Okay, and copies are to be duly furnished to the learned counsels for the respondents. Okay, Mr. Katu's name may, okay, appears on
Lordship.
here. Yes.
If I may,
Yes,
Lordship,
yes.
if the affidavits have not been filed, we'll file. If it
It's
has
not filed or not filed?
Actually, Lordship, we are under
So
the
we'll take
impression.
steps.
If
We'll
you're under the
take
impression.
steps. Okay. This after 2 weeks.
Major.
Yes.
Your Honor, here conducting counsel could not turn up due to road blockage at Alo.
Okay.
Mr. Aibam. The matter may be just after 2 weeks, Your Honor.
Okay, adjournment is prayed on behalf of the leading counsel, Mr.
Aibam. I am B type Odia, Your Honor.
Okay, Mr. So-and-so, for adjournment of the matter. Since the leading counsel is not able to appear today. In view of the above, list after
2 weeks.
2 weeks. What is the state? Yes, affidavit in opposition has been filed.
We have filed one.
Last court date, last chance was given to you. Isn't
We have
it?
filed Manish.
Okay,
For
who is
respondent
respondent number 3? Yes, so you have finally filed the affidavit in opposition.
Yes, yes.
So please complete.
Yes, Your Honor. Your Honor, here today only I have received the
Ah.
copy, so I have to go through it.
Okay.
If necessary, I would file my rejoinder, Your Honor.
Heard, Mr. Yes, who's for the petitioner, Mr.? Heard, Mr. So-and-so,
type.
learned counsel for the petitioner. Along with Mr. P. Compton, learned counsel for respondent number 3, and Miss So-and-so, learned government advocate, is it?
For 1 and
this-
2.
For respondents number 1 and 2. It is seen that respondent number 3 has filed the affidavit in opposition, and the learned counsel for the petitioner submits that he may be allowed to file the affidavit in reply if so advised. In view of the above, just after 2 weeks.
Obliged.
Yes.
Yes, and I frame some time, my lord, to file epidemic reply to the epidemic filed by the respondent, my lord.
Your
Okay.
Honor, Lordship, I have a prayer to make. Your Lordship, this petition can be dismissed with the liberty for appearing for letting them approach before the appropriate forum, Your Lordship. There is defective in this. Actually, they should have appeared before the civil judge junior division.
What is the civil revision about? It's against the judgment of the,
Yes, customary law.
Inter-place customary court, my lord.
in the customary court.
Inter-place, my lord.
Okay, then now,
Yes.
now the revision petition will have to be filed before which court?
As per the Arunachal Civil Courts Act 2021, Russian Amendment 2022, there is a, in section,
Where? Show
section
me that.
15, Arunachal Pradesh Civil Courts,
Yes,
Act
me.
2022.
Give me a copy of that.
For that, my lord, I believe, my lord, this matter, my lord, legal matter require some hearing, my lord, in this case, my lord, will be required. My lord.
What?
Some hearing, the elaborate hearing will be required in this case, my lord.
Is it required?
My lord. No, actually, your honor, your lordship, here, as per section 15, it is clearly written that provided that
So if you have come to the wrong forum, you can go to the
Yes.
correct forum.
no, my lord, my submission, I am not saying this is wrong for my lord. I am
Okay,
saying, my lord, this is,
okay,
yes,
so-
this is,
so we'll consider whether this is the High Court will be the correct forum.
My
Then I don't even have the Arunachal this
I
thing
have,
before me to have a
have the
look.
copy.
So anyway, so let him. So in your written objection,
They have raised it, my lord.
have you raised that issue?
Yes. So, my lord, I need,
You have mentioned that.
yes,
Then
yes,
you
yes.
make a reply to that,
Yes, ma'am.
isn't it? Heard Mr. So
Help me, ma'am.
learned counsel for the petitioner along with Mr. So and so, learned counsel for the respondents. The learned counsel for the petitioner has prayed for time for filing the reply affidavit to the affidavit in opposition filed by the learned counsel for the respondent. In view of the above, list after 2 weeks.
Interim is there, that may continue.
Interim orders there.
Yes, again, I have filed a contempt in that regard also.
Meanwhile, interim order passed earlier shall continue till the next returnable date.
All right.
My lord, in items 7 and 8, we have filed our affidavit, madam. And this matter will require some hearing, madam. In that
Okay.
event, my lord may admit and fix
Okay,
for hearing.
so pleadings are complete. Yes.
Admit the matter and fix for hearing.
I am ready to file my rejoinder.
Yes.
You've already filed or you want to file?
No, I have applied RTI, but they did not publish the required document. So
Oh.
I have filed an appeal before appellate court. So
Oh,
Let
so
them file
appeal
the-
is pending.
If they want to file a rejoinder, that liberty may be given.
Hmm. So you want to file your rejoinder affidavit?
yes,
Okay.
Your Lordship, I'm on item number 7. Petitioner said.
Yes, so this is 7 and 8. So you're appearing on behalf of item number 7.
7. Ticket.
Okay, you're for 8.
Eight.
Okay, Mr. So and so, learned counsel for the petitioner. NWPC number 464/2023. And Mr. So and so, learned counsel for the petitioner NWPC number 320/2023 are present. Mr. So and so, learned government advocate for the state respondents is present, and Yafo is also present. Okay, it is submitted. No, the learned counsel for the petitioner NWPC number 320, is it? Item number 8/2023 has paid for time for filing of their rejoinder affidavit. In view of the above, list after 2 weeks.
Interim is there.
Huh?
Interim is interim.
Meanwhile,
Modified-
the interim order passed out.
Modified
Shall
interim order.
continue till the next returnable date.
Yes,
Yes.
modified interim order.
Modified.
Interim.
No, there must be a,
Interim order was modified.
so, okay, meanwhile, the modified interim order shall continue till the next returnable date.
Obvious.
Item number 9. Yes.
Your Lordship, maybe kindly pass over the matter. The council is.
Your
engaged
Lordship,
in another-
Let us see the stage. What is the stage? Whether it requires to be, yes.
We have not received
County
the
defense
Paradise
not
reply.
yet filed.
Yes, Your Lordship, that's why I need some more time.
I heard Miss so and so, learned government advocate, who submits that further time may be granted for filing of the counter affidavit. Accordingly, list after
Three
weeks.
Your Lordship.
What? 4
Yes.
weeks? What is the matter
Yeah.
about which department?
From Your Lordship. Okay, so 3 weeks, Your Lordship.
Accordingly, list after 3 weeks.
Oblige, Your Lordship.
Yes, this was that long matter which we heard and we could not complete it yesterday.
Yes.
Isn't it?
Possible is better for time being. So I'm filing my affidavit now.
No. Malad,
Affidavit,
Yes.
okay. Yes, he had mentioned, you should have mentioned that before the long hearing that we had, that you have yet to file affidavit, isn't it? If you file an affidavit, you're going to give copies to both the parties. So we cannot continue, we'll release it from being part heard.
No.
So before hearing was, had started, you should have mentioned that you have an affidavit to file in this matter.
Malad, this is not a matter that it was heard for first time.
Huh.
Last time it was heard for my learned senior Malad. He had argued for more than 4 hours, man.
Huh.
That time
So,
also.
Then at that time you were kept quiet.
At that point of time, I was absent.
Malad, someone was present, Malad. We have almost concluded the Malad hearing, Malad.
So before the hearing had started, you should have mentioned that you have yet to file an affidavit
More
okay,
is
in opposition.
more performer respondent, my lord. If it was a
Ah.
main, then matter would have been different, man.
So what are you going to say?
Yes. It will take hardly 15 minutes, my lord. Before I.
Lordship may take at 2 p.m. Lordship may kindly see that order 8/4/2024.
Hmm.
The order was passed by this honorable court saying that matter would be heard next time and disposed of.
Hmm.
At that time, there was no question of filing affidavit, my lord.
Hmm.
Thereafter, 23/4, 6/5, 17/6, 25/6, 15/7, 18/7.
Hmm.
No, not a single day this was mentioned that they would be filing
Oh.
affidavit.
So why the sudden idea of filing an affidavit now?
My lord, I have got instruction from my client.
There are two after conclusion of hearing, well, almost. We have come to
Anyways,
the
but if they have to file, they have to file. We
Lordship-
cannot receive or refuse
but-
also. Okay,
Ma-
then, but after the filing of the affidavit, again, the counsel for the petitioner, you're going to receive the copy?
Yes, yes. My lord, let's see what sort of affidavit is it.
Yes.
If we find that, my lord, nothing to be rebutted, your lordship can hear the matter.
Oh. Anyways.
No, Lordship may kindly see the cost title.
Hmm.
There's 2 to 23 is performer respondent, page 7, Lordship.
Hmm.
Not even the main respondent.
The question is, my lord, if they really want to file, then why should keep some problem for future headache? Now,
I know,
supposing
we
if,
cannot refuse. We have to
Yes.
hear. We cannot refuse. If they pray, we cannot refuse because they have something to say in this
And
matter.
in that case,
and
Lordship
refusing
may-
to hear them. Okay.
Lordship,
So
then
anyways, the only thing which you can say is that after long hearing, that means you are very, very thorough with your matter then. And all the issues that can come up before the court, you have them ready
but
answer
this-
in the real final hearing.
Lordship, this
Isn't
case,
it? That's the only thing. There have been occasions, I have had experiences where 3 long days is wasted hearing one case and then it has to be released from being part heard because of something.
at
This
this moment,
happens.
your lordship may not say release from the parter.
Hmm.
Let it come at 2 p.m. Let's see what sort of affidavit
in that
comes up.
case, man, it may be released and fixed after 4 weeks, my lord.
Hmm.
Oh, no, no.
We will
My
have
lord,
No, we have not gone through even the affidavit, what kind of
Oh.
affidavit he has filed.
Yes, yes.
We have to, whether we have to file
So
reply to it or not, my lord.
Ah,
We have
exactly,
no-
exactly.
We don't know what
We'll
kind of
list it
affidavit is being
after
filed.
2 weeks.
Yes,
my
my
lord,
lord.
let it come, let it be placed at 2 p.m. Let's see, my lord, what sort of affidavit.
But
it
we
is.
will need to file
It
reply.
may not be necessary.
Yes, yes, so
We have not-
we'll release it from being part heard then.
We have
And
not
then we'll
even
fix
seen
it
that.
on maybe on a Monday before another bench, so that whoever sits will have plenty of time. If it stretches for 2-3 days also, it can go on. Okay.
Lord,
Yes, Mr. So-and-so, learned senior
your
counsel.
lordship is going to release it.
Yes, learned senior counsel for the petitioner, assisted by your, yes, the
Bhutia.
same name, okay,
Yes.
so-and-so. Is present along with Mr. So-and-so, learned counsel for the respondent.
Next Monday.
Then your good name, Mr. So, learned counsel for respondents number
3-23, except 6.
3 to 20, except respondent number 6. Submits that he may be allowed to file an affidavit on behalf of the said respondents since he has received instructions to do so. In view of the above, this matter is released from being part heard and is to be listed on, give me a date.
29th, my lord.
No,
29th of this month.
It may be listed after 2 weeks.
My lord, I am at receiving end, my lord.
No. Now, if it's 29th,
29th is a Monday, man.
no, on a Monday, but it'll be before the same court.
It won't be
And then,
possible.
and then this court will be having problems if I have to write a
Therefore, if your
judgment.
lordship release
the
it
whole-
from the part heard,
uh,
let it come in any of the bench.
We'll make it on, list it on her, after 2 weeks.
After 2 weeks, lordship.
My lord, your lordship will be here after 2 weeks.
No, I will not be here, but I'll release it from being.
So in that case, can it be fixed on 29th? That is on Monday.
No, 5th August, my lordship. After
No,
2 weeks,
5th,
well, definitely he'll need time, my lord, after that.
My lord, we do not know what sort of
List
affidavit.
on 5th August.
Yes.
Okay, in
Yes.
the meantime, the,
My lord, I'm sorry to say, on 5th and 6th, I'll be out of station. I'll be
Okay.
at Calcutta.
then when do we want it? On
So
7th?
29th is the best time for me because in the meantime, my lord, if the adjournment is for a long time, we shall forget everything again. We shall have to go for the study once again.
Case, it's your
So
case,
if
you
it is
want to wait.
29th memory will be fresh, my lord, there won't be any.
3 days, my lord.
Yes, I'm
He's
not
luckily
very
from-
inclined, I'm not very inclined to now, in a short date, to write the judgment, even if it's complete, okay?
Maybe 12th August, my lordship.
List on, okay, 12th,
In that case, my lord, let it be on 5th. I'll cancel my other trip.
okay, list on 5th, 8/2024.
Okay, obliged, lordship.
Obliged.
Wait, before, the learned counsel for the said respondents is to file the, affidavit before the fixed court date and to be duly furnished to the learned counsels for the.
And my lord, another prayer, my lord, if it is, my learned friend is filing the affidavit in the course of the day and any counter is required to be filed, it should be before 5th August. Otherwise, on that day again,
Yes. Is to file the counter affidavit within the course of the day and any rejoinder affidavit to be filed by the learned counsel for the petitioner is to be
petitioner
filed.
and the contesting respondent.
Okay, and the respondent is to be filed before the fixed date.
Yes.
Okay. Yes, list on 5th, so and so.
Obliged. Lordship is fixed on 5th.
5th.
Obliged. I feel your lordship will be here.
I don't know, let's see if I'm here, we continue.
I thought, my lord, we would be finishing up the matter today, my lord. New development has
But
come.
we cannot refuse.
I'm sorry
So,
to
but
senior, my
we
lord, he
cannot
comes from
refuse.
Guwahati, my lord.
No,
Yes.
but we cannot refuse.
Yes, my lord.
Filing out. Okay, yes.
Obliged.
Yes.
Item number 11 and 24 may be taken up together. It's the same matter coming about of same full PS case. 24. It was supposed to be taken up together on.
Supposed to,
Yes.
but was there an order that they should be listed together? They should be clubbed together? No,
Same PS, same prayer, same PS case, same grounds.
but different.
Petitioner, same accused are also together. There's a
Same
total of
petitioners?
petitioners is different.
Two
different accused. Two different accused, but same PS case. Bishop, this is an application for praying for immunity from prosecution under section 64A of NDPS Act and invoking sections 482 by quashing and.
So
setting
wait,
aside of-
now we look at the office order, okay?
Yeah.
Here it says that additional document to be
Lordship,
filed. You had prayed for filing of some additional document
No,
has to
Lordship,
be filed?
on the last occasion, there was a confusion regarding whether the institute from where they have gone treatment, whether they have been licensed or not. Now it came to knowledge that they are licensed. Otherwise, Lordship, this is a case where it's a case
related to section 27 and section 20B2A, which is a small quantity, and section 27, which is for consumption. And section 64A clearly states that when the accused has undergone rehabilitation, voluntary, and completed their treatment, the section 64A should be invoked, and they should be their immunity should be granted from prosecution.
What is the seized article is what?
Ganja.
Ganza, how much?
Uh,
Quantity is their charge under section?
Under section 20B2A, small
22
quantity.
A small quantity.
Yes.
So the
Initially, Lordship, when they were arrested, it was a chance recovery. Lordship may kindly come to page number 20. That's the FIR.
so the criminal petition is with regards to, okay, huh?
Page number 20. That's the FIR.
Hmm.
Married Lordship.
Yes, go ahead.
It is to inform you that today on 22nd/6/2024 and at around 19:30 hours, verbal information was received from Inspector so-and-so OCPS Itanagar that while he along with his team were investigating the theft case, a raid was conducted in the building of one Sri so-and-so located at so-and-so near primary school Itanagar, where three boys, namely Sangidorji, son of so-and-so, Premghantu Peshulpa, this son of so-and-so, and Sri Toy Karpak were found consuming cannabis in the room. Upon the receipt of information, police team led by undersigned and Sri Taip Maming along with SC Post Renas and other personnel proceeded to Division 4 Itanagar. All of them were apprehended. Then Sri so-and-so special magistrate NDPS and one independent witness of the locality was called and suspected house was searched, and a suspected cannabis weighing 355 grams and plastic bottles 250 ml, two numbers used for consuming drugs were recovered from the room and seized. Upon spot interrogation disclosed that they were drug addicts.
Anyway, your prayer is under section 482 for setting aside and quashing the FIR,
Proceeding.
the proceedings.
Yes, by granting immunity to the petitioner by under section 64A.
So when immunity is granted,
Yes.
can you actually set aside the proceedings?
Yes. There are judgment laws.
Oh, show me those judgments because it can. And let's see the NDNPS Act. NDNPS Act.
Into the
64A. Yes, read. So they have volunteered for treatment.
Yes, Lordship.
Where are they right now?
They've
been released.
Yes, they have been released, and I have annexed their discharge slip also.
Okay, read 64A.
Any addict who is charged with an offense punishable under section 27 or with offense involving a small quantity of narcotic drugs or psychotropic substances who voluntarily seeks to undergo medical treatment for de-addiction from a hospital or an institute maintained or recognized by the government or a local authority and undergoes such treatment shall not be liable to prosecution under section 27 or any other sections for offense involving a small quantity or of narcotic drugs or psychotropic substance, provided that the said immunity from prosecution may be withdrawn if the addict does not undergo the complete treatment of de-addiction. Also, in this case, also three of them were apprehended and apprehended on 22nd, Lordship, 22/6/2023, and on 28/6/2023, they were granted bail on the prayer that they will undergo treatment because they were addict and consumer. Now, out of the three accused, only two have completed their de-addiction course, and accordingly whereas the one couldn't complete, as such, he has not been discharged, as he has left the program in the midway. Now, both the accused who have completed their treatment are the petitioner in both the cases, both the petitions. And I have submitted the judgment from Karnataka High Court.
Yes.
Paragraph 9.
Now, this same prayer,
Yes.
have you approached the NDNPS Act, court?
Yes, sir. It was denied.
It was denied?
Yes.
What are the grounds for denial?
It was denied.
Anyway, just let's see the authority you're relying on.
Page number 18, paragraph 9.
Yes.
As the documents indicates that the petitioner is not consuming drugs now and that he has been completely de-addicted, should he be prosecuted in is the question. Section 64A clearly states that an addict who has undergone treatment shall not be liable to prosecution under section 27 or any other offense involving a small quantity. The word "or" is important. It is not that only the consumer of small quantity can claim immunity. That means if the addict has taken treatment for de-addiction, he cannot be prosecuted at all. Any further proceeding against him is in relation to offense under section 27 amounts to abuse of process of court. Sri Hashmat Pasha has referred to judgment of Madras High Court in Sanjeev Bhandakar versus State, and whereas observation is under. Given the attendant fact and circumstance, prosecution in instant case may at best be able to make out an offense under section 27 of NDPS Act. The question that arises for consideration would be whether the accused should be required to undergo trial towards his conviction for offense under section 27 of NDPS Act, and would he only thereafter be entitled to seek the benefit of section 64A of NDPS Act. Simply put, section 64A of NDPS Act is one intended to rid an user of drugs from the evil thereof and towards his rehabilitation. The end object being to facilitate a life free of drugs. This court is of the view that when the material gathered by the prosecution itself informs the petitioner to be a user of drugs and not in too large a quantity, the provision for rehabilitation should be given effect to at the earliest. It is to be noted that in offense under section 27 of NDPS Act, no distinction is made between small and commercial quantity. This court may hasten to add that a decision in each case to be arrived at the particular fact thereof.
Yes. Now it's time for lunch. Okay, so we'll continue at 2.
Milord, I am extremely sorry at this hour. In item number 26, Milord, one of our younger colleagues, on behalf of my brother Pangin, has made a mention for adjournment. In that, Milord, interim order was there. That may be extended. Milord.
Okay, 26.
26 and 27. Yes.
So we'll add interim order passed earlier. Shall
Shall
continue
continue.
till the next return
Yes.
date.
My lord,
Item number
it
26.
shall be grateful if my lord can make it till further order, because in the supplementary hearing list,
Hmm.
and adjournment is being sought for some.
But that's the next returnable date, and then in the next date, we'll see, maybe the matter will be taken up then, we don't know, no?
Correct, correct.
Mhm.
Great film.
Yes, so. So you've read the judgment, isn't it?
Yes, Lordship.
Oh,
So it states that when
so to set aside the proceedings,
grant immunity and set aside the
proceeding,
against the
as provided under section 27A of the NDNPS Act. I think that's your submission, huh? Anything to mention?
Condition precedent for invoking section 64A of the NDPS Act.
Hmm.
The alleged accused has to go a medical
So let's see the documents. Has he undergone the required treatment?
66.
Page number 66. He has undergone treatment for
Discharge slip, 45 days.
45 days.
Within 45 days can they be cured
Yes,
of
Lordship.
addiction?
And consular note has given that he is admitted in treatment center for the treatment of chemical dependency of ganja, has successfully completed his course in the therapeutic community and is being discharged today. And as for the other person, in item number 24, he was severe, so he has to undergo 90 days.
Okay, he's not, that's why 45 days only. So the other one is
Other
90 days.
90 days,
Completed 90 days,
90 days, and then he was discharged.
3 months. What sort of institution is this? Very good. Usually it's 9 to 1 year also.
And they are both well educated. They have completed their BA and has also had a BA degree. A young lady.
Okay, then accordingly, we will allow the criminal, I'll pass the order later.
In
Okay,
respect
and
of the present accused, because there are 3 accused altogether.
This accused, this is the petitioner, isn't it? In 73. Now, in the other one, criminal petition number 72, here it says he has completed 90 days.
Yes.
So only in these
In
two.
respect of these 2
These
accused.
So how can it be for anyone else? It has to be for these two,
Yes.
isn't it?
There are total 3 accused.
3
One
has
couldn't
not
complete
prayed,
it,
so it's not here. The
yes.
criminal petition is not here itself.
Yes.
Okay, so concern. I'll pass the order later, okay, because there's still many cases pending.
All right.
Allowed and disposed. Yes.
Yeah, please.
Bill application in this court, why?
My lord, 439, my lord, earlier I approached special judge, my lord. They rejected bail, my lord. My lord,
But wait, if you look at the office note, here it says that notice upon respondent number 2.
yes, my lord. To that effect, my lord, I have received a WT message
Hmm.
stating that the notice has been duly informed. I mean, the information has been duly given to the respondent number 2.
So then,
And for the
legal aid counsel or for, you are representing respondent number 2?
Yes.
Huh.
My lord, here is the case. Immediate position, there is no dispute. So far, the accused is concerned. As of now, he is 18 years, 10 months. The allegation made in the FIR is of something like 4 years back. Alleged during the recording of the statement under 164 of the purported victim, she only made stated that in her 164 statement that sometime 4 years back, she was raped by the present accused. Now, my lord, now there is no dispute that as on the accused means, my lord, if you go back, he was
Left behind by the dead parents, both of them are dead, is it?
My lord,
Or the mother is still alive?
no.
So-
After the death of the mother, my lord, they have filed an application.
Stepfather is still alive?
Dead.
Oh, okay, so the remaining children,
Yes, ma'am.
surviving children, step brothers and sisters, is
Yes,
that?
ma'am. Yes, ma'am.
So property is where?
No, my lord, this is not a, my lord, civil, my lord, title suit regarding civil dispute, my lord. This is legal hair certificate, my lord.
Okay.
A decree has been obtained from the district court, my lord, by committing fraud, my lord. We were not made as a respondent, my lord.
You were not?
Made as a respondent, as a party respondent. my lord.
Okay, without issuing notice.
Yes, my lord.
Was newspaper publication made? No.
Nothing, no. So, my lord, may I? Now, despite knowing the fact, my lord, they have filed a title suit, my lord. Page 16, my lord.
Page 16.
Yes, my lord. Annexure 1. This Rajan Muley, my lord. Respondent number 1. He filed a declaration for, my lord, legal hearing.
Okay, after obtaining the airship certificate, is it?
Yes, my lord. Now, basing
After
on,
being declared the legal heir,
yes, my lord.
without issuing notice, they
We were not, we are not the party here, my lord.
Okay, huh.
So, my lord,
So who was the respondent then? Who is the respondent in this case for title suit?
he is, my lord, respondent number 1 is, my lord, Mohammed Muley is the brother of, my lord, the respondent number 1, my lord. They are brothers, my lord.
Their brother.
They are from the first marriage, my lord.
Oh.
I am from the second marriage, my lord.
And who is the petitioner here? The plaintiff here?
Here, the respondent number 1, my lord.
No. If you look at page 16.
Yes, my lord. He
This
is
Rajan
Muley.
Muley.
Yes. Rajan Muley and Mohammed Muley are brothers, my lord. Blood
Okay.
brothers, my lord.
So you're not here. You're not in the
I am not
picture
here, ma'am. I am not here.
Okay. Hmm.
So why they are carrying that surname of Muley, my lord? I am carrying the surname of Tree, my lord, from my father, my lord. So what happened, my lord, in page 17, my lord, and
Yes.
paragraph 5, my lord. The petitioner states, my lord, the petitioner begged to submit that his mother died on so-and-so, leaving the petitioner and the respondent as legal heir of the deceased, my lord. Further, it is to submit that the said plot of land was inherited by the petitioner's mother from their father. Now, para 8, my lord, page 18, my lord. The petitioner begs to submit that he is in need of said legal heir declaration in order to get a transfer of landed property left by his deceased mother, my lord. Now, the prayer portion, my lord. It is therefore prayed before this honorable court to admit this petition and further be pleased to pass a decree in favor of the petitioner declaring him as legal heir of late Srimati Suchu Muley. And further be pleased to pass an order relief as deemed fit and proper. Now, basing on this, my lord, title suit, my lord, 19 of 2013, my lord, order, judgment and order was passed, my lord, page 20.
So the instant RFA is against this
Yes, my lord.
judgment and order.
Yes, my lord. Now facts, my lord, the background of the case has to be seen, my lord.
Judgment and order was passed way back in 2014.
Yes, ma'am. So we were unaware of the facts, madam, because we are not the party in this case, madam, in this suit, madam. Though I am also the son of my mother, madam, late mother. Now, what happened in the year in September 2015, madam, I came to know that the respondent were trying to grab the land, madam. So why, madam, I filed a complaint, madam, before the, I filed an appeal before the deputy commissioner, page 40, madam. This is my plea on wrong forum, madam. I'm praying for section 14, madam. Benefit of section 14. Madam. May I, madam? Page 40 to the deputy commissioner, madam. This is on 24/9/2015, madam. This is the time when I come to know about this judgment. Memorandum appealing the grant of stay on the process of transfer of ownership in all immovable properties regarding in the name of Srimati Suchu Muley, madam. With reference to the aforesaid matter, it is here submitted before you with the following facts for your kind perusal and taking further necessary action, please. That, sir, it is submitted that once Rajan Muli and Srimati Momen Muli both.
Anyway, we'll just look at the dates. So you come
Yes,
to the
yes, yes, sir.
picture in 2015.
Yes,
Before the deputy commissioner.
Yes,
Then what happened?
then, my lord, this notice was issued, my lord.
Yeah.
Now, my lord,
2016.
yes, my lord, notice was issued in year 2016 requiring us to be present on 29/4/2016.
So it was pending before the
Deputy
deputy
Commissioner, yes,
commissioner
ma'am.
till finally a judgment was passed, isn't it?
No, my lord, and then
2017.
on 28/4, we filed an application for adjournment of the matter because
Oh,
I was
already,
not in the
yeah.
station. And then, my lord, yes, judgment. Judgment is of
2017.
2017, yes, ma'am.
So appeal
2017.
against the order
So, my
of
lord,
the
what happened?
deputy commissioner is to whom?
Yes, Deputy Commissioner, my lord, has passed an order, my lord.
Hmm.
On the ground, on the basis that the legal hair declaration certificate is with the respondent number 1. So, why, my lord?
Against you. So you filed an appeal?
Yeah, not file an appeal, my lord. We file an application, my lord. Now we file an
So
application.
till 2017, it
Yes,
has been explained. Okay,
Yes, ma'am.
2017, after the judgment of the deputy commissioner, can you
Yes, ma'am.
explain that?
And then, my lord. So we have approached in the wrong form, my lord. Now, my lord, coming to know about the facts, my lord. We file an application, my lord. We filed an application before the district judge, my lord.
Hmm.
On, my lord, we were unaware of this order, my lord. We came to know about this order in the month of February 2021, my lord.
What order?
Order of the
See,
deputy commissioner, my
You
lord.
had gone to the deputy commissioner, so
Yes,
you were aware of the case.
Yes, my lord. But this
Then-
order, my lord, final order.
Huh?
Final order was never come, my lord, we were not served with the order, my lord. So we were unaware of the order, my lord. Now,
Which
what?
order?
Order of the
2007.
deputy commissioner, my lord.
Okay, you were not a party then?
No, I was a part in the
Then-
in the proceeding of the deputy commissioner. I was the party, my lord.
You were a party,
Yes.
then the judgment was issued on
Yes.
2017.
Yes, my lord.
So you
So,
should have
my lord-
inquired what happened to your case.
And then, my lord, in between, my lord, I was appointed in the civil service, my lord, or state civil service. I was in my, my lord, in my training, my lord.
Where's that? Where's
I
the
have stated
document?
in my affidavit, my lord.
This is way back in 2017. You had
Yes,
a
ma'am.
dispute, judgment was
My lord, para 4, I would
disposed
like
in
to read.
2017.
Yes, ma'am.
And then you're saying that then you should have inquired about your case.
Yes, my lord, my lord,
Oh.
para 4, my lord, page 18 would be relevant, my lord. May I read, my lord? It is an admitted fact that since the applicants are laymen to law and its procedure, the applicants inadvertently approached wrong forum before the deputy commissioner Lohit district. It is stated that upon filing of the complaint, the applicants got engaged in their usual work. The applicant number 1 went to Delhi for preparation of civil service, and after selection in Arunachal Pradesh civil service, he was engaged in his new service life. The applicant number 2, being a chartered accountant, went back to Pune to join his duty. And the applicant number 3, being a married woman, went back to Lower Dabang Valley district to join her family life. Pertinently, later, without the knowledge of the applicants, the deputy commissioner Lower district passed an order dated so and so in favor of the respondent number 1.
Way back in 2017.
Yeah, it is to state that the applicants were unaware of the order dated 23/2/2017, as the same was never intimated to the applicants. The applicants learned about the order dated 23/2/2017 only on February month of 2021. Consider being known about the impugned judgment on decree dated 21 to passed in title suit number so and session judge so, the applicants after counseling have immediately filed interlocutory application, my lord. IA number 03 of 2000 in title suit number so my lord, on 21/2/2021. By stating that respondent number 1, by committing fraud upon the learned court below, has procured the judgment and order decree dated so. Thus, the prayer was made to revoke the legal hair certificate given to the respondent number 1. Now, my lord, this is not disputed by the respondent also that I am the son, we are the children of our late mother, my lord. Now we file an application and the application was filed under wrong provision, my lord. So why, my lord, this we have withdrawn our application, my lord, page 51, my lord. Yes, my lord. This, my lord, learned counsel fee of the applicant, for the applicant, and learned counsel B. Biswas for the respondent is present. Mr. Cree submits that he has filed this application under wrong provision, hence, he phrased that he may be allowed to withdraw this petition with a liberty to file a fresh one. After hearing the council's prayer aloud with this application instance disposed on being withdrawn, my lord. Now, after being withdrawn, my lord, this writ petition, my lord, the file was with the, my lord, the learned counsel, Mr. K. Cree, my lord, P. Cree, my lord. So in the month of October, my lord, from the date of withdrawal, my lord, on 31/3/2022 till, my lord, September 2022, my lord, the file was with Mr. P. Cree, my lord.
So you
So-
could have
so-
corrected it.
Yes, my lord. On October 2022, my lord, we have the applicants have changed the council, my lord. And from October till filing of IA, my lord, this delay has been caused, my lord. This appeal, my lord, this application, my lord, has been filed on 9th February or 9th November 2022, my lord. Now my case
Ninth
is
what? 9?
9 9/11/22, my lord.
Application what? What application?
For condonation of delay and this appeal, my lord, first appeal, my lord.
2022.
2022, yes, my lord. On 9/11/2022, my lord.
Okay.
Now, since all the applicants are residing in different locations, my lord, from October to filing November, my lord, it took some time, my lord. Applicant number 2 resides in Pune, my lord. So we have to get the wakalatnama of applicant number 2, my lord. And applicant number 3 is in Lower Davangal. So, my lord, my simple case is that, my lord, fraud vicious everything, my lord. They have
What
committed
fraud
fraud.
was committed?
Yes, my lord.
What fraud was committed? They are also the children of the deceased?
Yes, my lord, they, my lord, are required to make us as a party, my lord, because they have made a declaration that they are the legal heir. I am not the legal heir. How can they say that, my lord? In their para 5, my lord, they have stated, my lord. May I, my lord, page
That's
17,
not
my lord.
the fraud, that is them saying that we are the legal heir. You're also
Yes.
fighting.
So, my lord, there is some concealment of material facts, my lord. This is direct, clear material facts, my lord, has been concealed, my lord. My lord, please appreciate para 5, my lord. And
Para
legal
5.
hair certificate, my lord, page 17, my lord.
17.
Yes, ma'am. Whether I am not a necessary party, my lord. The petitioner begs to submit that his mother died on so leaving the petitioner and the respondent as the legal heir, my lord. How can they say, my lord, they are only the legal heir? I am also the legal heir. I am a necessary party, my lord, in the proceeding, my lord. My lord, by way of this, my lord, they have obtained, my lord, land measuring 8,000 something square
Okay,
meter.
who are the children of this Muley?
Muley, my lord, respondent number 1 and 2, my lord.
You are not the son of Muley?
I am also the son of Muley, or I am son of 3, my lord, from second. This legal hair
You
certificate.
are the son of the
Three.
wife, not the father.
My
Or
lord-
you also the son of the, you are also the biological son of Muley?
My lord, this Muley Cree, same thing, my lord, because the mother, my lord, after marriage, my lord, he has changed the surname, my lord. First, she was married to Muley, my lord.
No.
After the date of Muley, she married to Cree, my lord. Second husband, my lord. Cree is the second
So
husband.
you are the son of the first husband or the second husband?
Second husband. my lord.
Second husband.
Yes, ma'am.
While the petitioners are the son of the first husband. Is it? The respondents.
Respondent, yes, my lord. Now,
Son
this
of-
hair certificate is for, my lord, this mother, my lord.
So, no, what I'm trying to understand it is the concealing of facts or not.
Yes.
Now, the respondents will feel that since the land originally belonged to their biological father,
My lord.
they must be feeling that they should be actually the legal heirs, not the son of the
No.
second husband.
Yes,
Maybe that's
Malad,
why.
this may be considered, Malad. Malad, this legal hair certificate, Malad, the decree that has been obtained, it is with regard to the mother, Malad, not the father, Malad.
But the mother
Yes, Malad.
got the land from her first husband, maybe, or was it her personal?
That has to be,
land?
Malad, heard, Malad. That has to be heard, Malad.
That has to be her.
Heard,
Yes,
yes,
yes.
Malad, yes.
But
Now, without hearing us,
no,
Malad,
you're claiming that the fraud and all that. I'm just saying whether they could actually be a
separation
fraud.
of material facts, Malad. It's paragraph 5, Malad, there is a clear separation of material facts, Malad. They are saying they are only the legal hair, Malad.
Because according to them, their property originally belonged to their biological father.
That
Isn't
has
it?
to be
I have
heard,
a
Malad.
feeling that's what.
Yes, Malad.
Isn't it? So whether fraud is committed or not, you have not made out a case concerning that.
Malad, this
But
be that has been made, Malad, they may say it belongs to, this is their
yes,
statement, this
that
is
will
their
be their
statement.
stand,
Yes,
because
that is their
going to
statement.
be their stand.
Yes, yes.
Oh.
Now, their stand cannot be taken as a gospel truth, Malad, because I was not there. This has not been cross-examined, Malad.
So your prayer is that I should also be made a party. That's
Yes,
all.
Malad, I
Isn't
should
it?
have been heard, Malad. They, by this para 5, Malad, they have concealed the material facts, Malad, by stating that they are only the legal heirs, Malad, of Srimati Suchu Muli, Malad, or Suchu
Yes,
Kri,
that's
Malad.
according to them.
Yes, Malad.
The correct thing should have been noticed, should have been issued, whether anyone was interested or not.
My lord,
Which
I
was
was
not.
interested, Malad. Yes, Malad.
Which was not. Anyways, go ahead.
Malad. Now, I will go straight to Malad fraud, Malad. 2000.
No fraud, no fraud. I find that no fraud has been committed. You see, because the petitioners in this case,
No, no.
since the property belonged to their biological father.
No, mother, Malad.
No, no.
May I, Malad? Malad, may please come to order of the Malad, this Deputy Commissioner, Malad.
Initially belonged to their father or initially belonged
Belong
to
to
their
mother, Malad, mother.
Okay, it was their mother's
It was
property.
allotted to mother, Malad.
Okay. Anyways, whether fraud is committed or not, that's a different matter. We are looking into the condonation of delay.
Yes, Malad. No, in the condonation of the frauds matter, Malad. There's a Supreme Court judgment, Malad, which says frauds reshapes everything, Malad.
See, we will look.
On condonation of delay,
delay. For 2017, order
ma'am.
was passed by the Deputy Commissioner on 2017.
Yes, ma'am.
Okay. Now, your plea is that I was not aware of this order.
Yes, ma'am.
You woke up in 2021.
21. Yes, ma'am.
So you will have to explain these 3 years. Okay. Now you're saying that these 3 years is due to the fact that you were posted somewhere else.
Yes, ma'am. Yes.
You never took the trouble to inquire what was happening to your case. You were a party before
Yes,
the
ma'am.
Deputy Commissioner.
Only in the month of February 2021, we came to know. And immediately we filed an application before the district judge, madam.
You never inquired what happened to your case? You were a party before the Deputy Commissioner.
Yes, madam.
You had, so the final hearing was there. You're waiting for the judgment to be passed by the Deputy Commissioner.
My lord, may kindly
But you did
appreciate
not do
on,
anything.
on 28 April 2016, my lord, we have
Okay,
filed an
yes.
application for adjournment, my lord.
Okay, let's see that.
Page 43, my lord.
Hmm.
On the top, my lord,
Yes.
28 April 2016, my lord.
Hmm.
Deferring someone of B2 and so increase with respect to so and so. That's it has been brought to my notice that today on so and so that a letter has arrived at my home in Teju asking me and my brother Sondi Kri to report to your esteemed office in connection with disputable change of title to a plot of land in the name of Rajat Muli, son of Goke Muli. That's currently I'm in Itanagar anticipating to the start of training very soon after my selection into Arunachal Pradesh Civil Service 2016. The process of joining service is underway with start of medical examination fixed on first week of May. Further, my brother Sondi Kri is engaged with Grand Terminal so-and-so as a chartered account in their Pune office. Yes, sir, given the above circumstance, it is not possible us to report to your office on such short notice. Further, ancestors range have blocked communication by a shorter route from Itanagar to Teju, and it would not be possible for me to report to your office by tomorrow. Therefore, sir, it is humbly prayer to you to kindly defer the date of reporting to your office and kindly intimate us at least with 1 week in hand of any future dates so that we can plan accordingly, madam. So after that, my lord, there was, this is of 2016, my lord. Then, my lord, there was no process, my lord. Suddenly, 2017, this order has come, my lord, which
So
was,
ex parte order?
it is not an ex parte order, but it was not communicated to us, my lord.
Were you represented?
My lord, this was passed directly by the deputy commissioner without my lord, this order may be, may I read the order, my lord?
So
With-
were you
I was
so
not
this-
present during the passing of this order, my lord.
passing of the order?
Yes, ma'am. There's
But
no
when was
recording
the
of,
hearing held? Anything? When was the hearing? At the time of hearing of the matter, were you represented by a counsel? What?
no, my lord.
Nothing is there?
No. No, my lord, may I please come to my lord, page 44, my lord, second paragraph, my lord. That on the other hand, Mr. Rajan Muli, who is stated to be the legal son of late Suchu Muli, late so and so of medical road, obtained a legal hair declaration issued dated so and so by the Honorable District Judge Teju, wherein it is mentioned that Sri Rajan Muli is the legal heir of Srimati Suchu Muli. This certificate has been issued with regard to, my lord, late Suchu Muli, my lord, who is also known as Suchu Kri, my lord, of and late so and so, and accordingly applied for getting transfer of plot of land covering deck number 125 and 125A, measuring 8,120 square meter. This land was allotted to my mother, my lord. Now they, by virtue of that, my lord, decree, my lord, they have occupied the entire land, my lord. Now this order still states, my lord, the order of the district judge of the year 2014, my lord.
No, I'm just saying whether you were made a party. You were made a party, but how did you not know about the judgment? Last is when summons were issued to you, and then you had prayed for adjournment.
Yes, my lord.
Then were you represented when the judgment was going to be made? So
No,
that
my
we
lord.
can
No,
sort
it is
of-
not recorded in the order because we never represented on that day, my lord. Was not there, my lord.
So you never appeared.
Yes, my lord.
So just look at the finding and observation, page
Yes.
45.
Yes, ma'am.
Number 3, you are which one? Cree, number 2. serial
Yes,
number
Cree.
2.
I'm B2 Cree. Yes, my lord.
So this B2 Cree fails to produce any document. So you had not
My lord,
produced
this,
any
this
document.
finding is very different, my lord, because this order, my lord, of the deputy commissioner has been passed on the strength of order passed by the district judge, my lord. It is reflected here only, my lord.
Where?
My lord, last order, my lord. From the finding and observation after going through the material placed on record, I am of the view that dispute land as reflected above belongs to Sri Rajan Mili on the strength of legal hair declaration dated 21/2024 passed by the so and so, my lord. On this strength, my lord, this order has been passed on.
So where's this order of the district judge?
District judge, my lord, this first order, my lord, which I am challenging, my lord.
Okay.
Page 37, my lord. I am not the party here, my lord. I should have been made party, my lord. Because of that, there is a separation of material facts, my lord. Because I am also the legal heir of my mother, my lord. That has to be
So-
decided whether
yes.
this,
So you were not a party here.
yes, ma'am.
And the deputy commissioner passed an order on the strength of the order passed by the deputy commissioner.
District judge, yes.
So, district judge, so it appears that when this judgment was made by the deputy commissioner,
Yes.
you were not around and you were not heard, it appears.
Yes, my lord.
Though the ex parte order is not mentioned. No, because I'm trying to find out whether your submission that you were not aware of the order 2017 is
Yes.
believable or not.
My lord.
Okay.
Because, my
Reasons
lord,
have been given.
I was not there. Even in the order, it has not been reflected that today this person is present, my lord. We were not there, my lord. And it was never communicated to us, my lord.
Okay.
No.
Yes.
Now,
Then-
my lord, I would like to
After, then you filed the complaint in 2021, you got to know about it. So 2022, you took the steps, is it?
2000, yes, my lord. In the year February 2021, I came to know, my lord, about this order, my lord, of the deputy commissioner, my lord. And then, my lord, I filed a, my lord,
application, my lord, before the district
Wrong
judge.
forum.
That starts from, my lord, page 23, my lord. So it was filed on, my lord, may please come to page 35, my lord. 34 and 35, my lord. 21st February 2021, my lord. Immediately we have filed. This is our affidavit, my lord. I have filed an interlocutory application number 03 of 21, my lord. Now, my lord, may come to page 23. This is the, my lord, index, my lord. Page 1 of the petition has been missing, my lord. In the original record, it is also missing, so we could not produce, my lord. But page 23, my lord.
Okay,
Yes.
yes, I've seen.
Yes. So on 21st February 2021, we filed an application before the district judge, my lord. In IA in title suit number 19 of 2013, my lord. As we were unaware of the, my lord, this proceeding, my lord. So why we have prayed for, my lord. Our prayer was simple, my lord. My prayer, my lord, may please come to page 30, my lord. Under the circumstances, it is hereby prayed that your honor may be pleased to revoke the certificate granted to the opposite party in title suit number so and so. My lord, with regard to our application, my lord, they have filed also objection, my lord. Respondent herein, my lord. Page 46, my lord.
Before the district.
Yes, my lord.
Before
They
the
have filed
circuit
written
judge.
objection. Yes, my lord. They have filed written objection in page 4. My lord, may please come to page 47, my lord, para 9. My lord. They admits that, here they admit that, yes, we are also the biological child of Chuchukri, my lord. My lord, that reply to paragraph 1 of the plan is admitted to the fact that petition are the biological child of Srimati Chuchukri are admitted.
Okay, leave it. So then you went and you filed the application before the district
District
judge.
judge, ma'am. Yes, ma'am.
Then
Due to filing in the under wrong provision, my lord, we have withdrawn, my lord, page 51. Ma'am. We withdrawn, my lord.
yes.
And after date, my lord, I have filed an application. My lord, this after 31/3/2022, my lord, the file was with the learned counsel, Mr. P. Cree, my lord. Counsel. The counsel in the
31/3/2022.
31/3/2022, yes, my lord. It was withdrawn. And until September 2022, my lord, it was with the learned counsel, my lord. And in the month of October, my lord, the applicants have changed the counsel, my lord. And then and in the month of November 2022, we have filed an application, my lord. Now, during this period, this time, my lord, we took for preparation of the appeal, my lord, and to seek signature of applicants in the Wakalatnama, because they are residing everywhere. My lord. Someone is in Pune and other one is in Lower Devangali, and this applicant number 1 was discharging his duty as a public servant. My lord, I will straight away come to the point, my lord. My lord is satisfied whether this is a suppression of material facts, my lord. Because, my lord may kindly consider this application, the decree, my lord, which they have obtained from the district judge, is regard to the death of, my lord, Suchukri, my lord, also known as Suchumuli, my lord. And this land.
We'll concentrate only on the limitation, condonation.
Yes.
So you explained the condonation, why you, so you have explained. What else to say?
My lord, my submission is that I first want to satisfy your lordship, my lord, there is a fraud, my lord. There's a misrepresentation of facts, my lord. Because if it is
Why
established,
did you delay so much?
well, I was unaware of the fact, my lord. In the year
So you come to
2015.
that, you come to that, you were unaware of it.
Yes, my lord. In the year
Whether
2015.
fraud or not, that's a different matter.
Yes, my lord.
So that we will look maybe in the appeal or whatever,
My
okay,
lord.
where the fraud was
No, my lord,
committed.
my lord, this has been settled by this, our apex court, my lord. 2002 9 SSC, my lord. But cardinal principle, my lord. Fraud vitiates everything, my lord. This is also applicable in, my lord, condemnation of delay.
Let's see.
My lord. My lord, may I please come to para 4, my lord. May I read, my lord?
Yes.
That the order of the Commissioner Appeal was passed on 14/6/1995. my lord. Order was passed on 14/6/1995. In November 1996, my lord, after overall limitation, my lord, in November 1996, acting upon intelligence then received, the Central Intelligence Unit of the Mumbai Custom House commenced an investigation on it. It was then revealed that there was reason to doubt the veracity of at least some of the aforesaid statement documents upon which the respondent had relied, my lord. Now, para 5, my lord. The appellant thereon filed the appeal before the Custom, Excise and Gold Appellate Tribunal, whereon the other order under challenge was passed. It is sought condonation of delay in filing the appeal, setting out in some detail the reason for which appeal had been filed after the period of limitation. The tribunal declined to condone the delay, taking the view that judgment of this honorable court in so and so was applicable and that it could not look into the nature of grounds of appeal. Now, para 6, it is important. The tribunal would appear to have lost sight of the cardinal principle, which is enshrined in Section 17 of the Limitation Act, my lord. Limitation Act, my lord, Section 17 says, my lord, within 1 year it has to be filed, my lord. Within 1 year it has to be filed. Section 17, my lord, says within 1 year it has to be filed. But, my lord, here Supreme Court has carved out an exception, my lord. May I read, my lord? The tribunal appeared to have lost sight of the cardinal principle, which is enshrined in Section 17 of the Limitation Act, that fraud nullifies everything. If the tribunal was satisfied, as it ought to have been, upon this fact, that there might be some fraud, there was very reason for it to condone the delay and to hear the appeal. The appeal is allowed, appeal is allowed, the order under appeal is set aside. The application for condonation of delay is allowed. The tribunal shall now hear the appeal on merits. Even our High Court has passed similar order.
But the facts of the case we have to see. Isn't
Yeah,
it?
also
You are trying to impress upon the fact that since the children have not mentioned about other children, fraud is committed.
No, my lord, it is on suppression of facts, my lord.
Anyways, let's see.
My lord, may please come to para 5, my lord, page 5, my lord. This is the facts, my lord, background of the case, my lord, which have been observed, my lord. Page 5, my lord, para 5, my lord. May I read, my lord? MS Chaudhary submits that the rejection of delay of condemnation application by court below was not proper. In support of her contention, Ms. Chaudhary submits that Section 17 of the Limitation Act 1963 specifically provides that period of limitation shall not begin to run until the application discovered the fraud with a reasonable diligence and until the first application had the means of producing the concerned documents. In order to satisfy the court below, the petitioner produced both the sets of GD entries and was successful at least prima facie to show that a fraud was played on the tribunal in the said MSC case number so and so. But as against the said principle of Section 17 of the Limitation Act, the learned counsel below had the insurance company failed to explain the delay from the period of 11/3/2004 to 9/8/2005. It is the contention of the learned counsel that in order to discover the fraud, it's quite natural that some time was consumed, but the ground is specified in the impugn order is in a case like the one in hand, where there is a strong famous case in favor of the petitioner. The learned court below was wrong in passing the impugn order. 6, my lord. Mr. Hussain.
This is fraud concerning GD entries, isn't it?
My lord, para 6, my lord, this is the background of the case, my lord, sir. No, exact case, my lord, would not be there, my lord, but the para 6, my lord.
So your plea is going to be that you were not aware of the judgment, okay, 2017, because you were not made a party in the previous order
Yes, my lord.
passed by the district cancellation judge.
And I was not the
Okay.
party since there is a suppression of material facts, my lord.
No, because you were not, because that is the main ground while you have come on appeal, isn't it?
Yes, my lord.
That you have a right to be made a party.
No, my lord. I say, my lord, upon committing fraud upon the court, my lord, by suppressing material facts, my lord, that they are only the legal heir of Mr. Miss Srimati
But
Kushal
you're
Devi.
fighting for legal heirship.
Yes, my
Okay.
lord.
So they are saying that we are the legal heirs, you are saying that you are the legal heir.
We both
So
are legal
now-
heir.
So you have to now establish who is the legal heir. Okay, that is your case,
Yes, my lord.
isn't it? So that is your case as to who is the legal heir of the deceased, so and so. So now your case is that you were not made aware, okay, or what, notice was not issued?
No, 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 not, that is not my case. My case is that they should have, my lord, stated the facts, my lord. Who are the legal heir? They only stated that they are only the legal heir, my lord.
You're saying that they should have mentioned all the children.
Yes, I should have been made as a party, my lord, because they should have mentioned that they, who are the legal heirs, my lord. I am also the legal heir. My lord, may please.
That is the issue in dispute. Who is the legal heir? Both of you are saying that we are the legal heirs. I don't know what is your custom, but when someone dies, it is not as if all the children are the properties distributed to all the children. Is that the custom here? That it has to be distributed, or someone can also get all the properties?
No, my lord, the children, it has to be distributed amongst the children, my lord.
Okay, that is your custom.
Yes, my lord.
Where?
The custom is the practice, my lord. Now, my lord, may please kindly appreciate para 6, my lord, of the judgment, my lord.
Okay.
This, my lord, these submissions are the background of the case, my lord. Para 6, my lord.
You see, because my hesitation is saying that, okay, you are also made a legal heir. Then we are kind of deciding the case that both of you have to be legal heirs, while the prey of the case of the present respondents is that they are the legal heirs. Okay. And now you are saying that I have to be made a party because I am also the legal heir. Then you have to establish that you are also a legal heir. And then how to distribute the properties, isn't it?
No, my lord. The thing is, my lord, my late mother, their late mother
Is
are
their late
same,
mother, are
same.
the same.
We are, my lord, step brothers, my lord. Now, when you file a legal heir certificate, my lord, it has to be disclosed, my lord, who are the legal heirs, my lord. And upon that, my lord, the decree are passed, my lord. Now, what happened, my lord? They have.
So when you file a legal heir certificate, let's see the application.
Well, this is the suit, my lord. Title suit, my lord.
I'm still not convinced because we have so many cases like this where interested parties are not informed, but they have to establish as to how they are also
My
a
lord,
necessary
let's say like, my
party.
lord, in succession certificate, my lord.
Uh-huh.
It has to be disclosed who are the, my lord.
Notice is usually issued.
Yes, my lord. And it has also been disclosed who are the, my lord, the children's, my lord, and the, my lord, dependents, my lord. The list of dependents has to be, my lord, stated in the petition, my lord. It is in the format, my lord. So it is required, my lord, and they himself, my lord, has stated, my lord, they are only the legal heirs.
Anyways, so you're saying that fraud has been committed.
Yes.
Next, anything else?
My lord, may please appreciate this judgment, my lord, our High Court judgment.
So we have read, you have read. Then let's hear the respondent also.
My lord, what I say, my lord,
Uh,
my lord, may kindly first read this judgment, my lord. This would be necessary for me because this has some bearing in my case. My lord.
yes.
Para 6, my lord.
So leave it at that. You have read.
Yes, ma'am. Now, this background is important, madam. Mr. Hussain, on the other hand, vehemently objects to the submission of Mr. Chaudhary. It is submitted as per the contention of the petitioner. Fraud was discovered in the month of February 2011. And since then, the said petitioner sat idle and filed a review application in the year 2014. The said period of 3 years remained unexplained as such. Mr. Hussain submits that the learned counsel below was correct in passing the impugn order. It is further submitted that Section 17 of the Limitation Act 1963 prescribes a period of 1 year from the date of discovery of the fraud. As the said period of limitation is mandate of the law, under such circumstances, the learned court below was correct in rejecting the application, more so when there is no explanation at all from the date of discovery of the fraud in the year 2011 till the date of filing in the year 2004. Now, considering the submission, my lord, para 7, my lord, considering the submission of the learned counsel, I have perused the impugn order and copy of the GD entries annexed to this petition, my lord. In the case of SP so and so, the Honorable Apex Court had held that a fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. It is a cheating intended to get an advantage. A litigant who approaches the court is bound to produce all the documents executed by him which are relevant to the litigation. if he withholds he withholds a vital document in order to gain advantage on the other side, then he would be guilty of playing fraud on the court as well as on the opposite party. And if a judgment is passed in such a situation, the said judgment is a nullity, my lord. Para 8, my lord.
Okay, you can finish because I don't think fraud has been committed. You were a party before the deputy commissioner. You were there. You were
No,
a
first
party.
order, my lord, first order. I'm not against the order of the deputy commissioner. The decree has
So,
been passed.
so your appeal is not against the dated 2017.
No, my lord. I'm against the decree, my lord. Decree passed by the district judge, my lord.
But what about the judgment of the deputy commissioner?
Deputy commissioner, my lord, that is not a court, my lord. That is not a court, my lord. The decree, my lord, on the strength of the decree passed, judgment
But
passed by the district judge.
you were there a party before the deputy commissioner.
Order of the deputy commissioner, my lord, whatever it may be, I cannot challenge in the appeal, my lord. Before this honorable court or the district court, my lord. I can challenge the order
You're
of the.
twisting the, anyway, let's hear I've heard your submission. Heard. Yes.
Yes, your lordships. The main contention is that he had learned about the order passed by the district and section court in the year September 2015.
Oh, 15.
The impugn order which
Oh.
challenging hearing. So according to him, there is a delay of 3,154 days.
Hmm.
So may I come to that? Before that, he had filed an application under Section 5 of the Limitations Act. So what Section 5 of the Limitation Act says? Yes, I will go with Section 3 first. Limitation of suits, appeal and application.
You don't have to read the limitation, huh?
So
Section five, huh?
what it says means bar of limitations subject to the provisions contained in Section 4 to 24. Every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed.
Hmm.
So here the term shall is used, although limitation has not been set up as a defense. Even if I don't set up his application as a defense, then court is bound to dispose it of. Now I will come for the purpose of this act as suit is. Now I will come to Section 5.
Hmm.
Extension of prescribed period in certain cases where the limitation can be extended. May I read? Any appeal or any applications other than application under any of the provisions of Order 21 of the Code of Civil Procedures may be admitted after the prescribed period if the appellant or the applicant satisfy the court that he had sufficient cause for not preferring the appeal or making the applications within such period. Now, if I come to his applications, he had not explained any sufficient cause in his application. Though he is saying that he was there at Pune, he was taking coaching, he was giving examinations for civil service, but he had not annexed any document to authenticate it, the claim he is making. So until and unless he support his claim with supporting documents from the authority or the institution where he was studying or under which chartered accountant he was practicing, there is no any such certificate he had annexed. It is admitted fact that he had learned about it in 2015. So from 2015 onward, what he was doing, he had not explained, only simply saying that the petitioners, one was there at Delhi, one was at Itanagar, another was Pune, but there is no any proof. Authentic document he had annexed with these condonation applications. From this particular period to this particular period, I was at Pune. Or from this particular period to this particular period, I was taking coaching. Or from this particular period to this particular period, I was under training. So he had not explained. He had not explained any sufficient cost in his applications. So until and unless he explained a sufficient cost. Now the thing is that whether in this condonation applications, merit of the case can be discussed. Because
But he mentions that he got to know about it later. And
Yes.
then he approached the deputy commissioner.
Deputy commissioner, but he cannot take the plea that he is unaware of that order. He himself is admitting that he had learned about it in September 2015 in his own applications.
Hmm.
So he had to explain from that particular date, September 2015, what he was doing. He had not explained it. Only he is putting an allegations on DC that he had not intimated to us or it was not. Even if the orders which he was referred to, the order passed by the deputy commissioner, which is page 44. May I read the very first line? The brief of the case is that once Bittu Kirisanabis has filed an application, This order was passed on his application. So question of expertise doesn't arise here. So he should have taken interest. What had happened to his applications? He had not explained it, why he had not taken interest to know about his applications, what had done, what had happened to these applications. And again, he had filed an IA before the session court, which was withdrawn on 31st/3/2022. Only the blame he is putting on the advocate who appeared before the court. This application, because he had not alleged in the applications that that particular advocate had withdrawn this application without his consent.
Is it there?
No, he had not alleged that. In his applications that the particular advocate who appeared in the session court, district court, had withdrawn his IA without his consent. So that means his consent is there.
Is it that what happened, that he had withdrawn his
That's order is in 51,
page 51?
page 51. Learned counsel P. Kiri for the applicant and learned counsel for the respondent is present. Mr. Kiri submitted that he has filed this application under wrong provisions. Hence, he prays that he may be allowed to withdraw these petitions with the liberty to file afresh. That means he has the knowledge. Even in the condemnation applications, he had not said that he had not asked his counsel who was appearing in the district court to withdraw this without his consent. No such averment is made in the applications, except the allegations that he kept the file with him. That means he had the knowledge. Under his instructions only, that application was withdrawn. May I come to a recent judgment passed by our Supreme Court in this regard?
Yes. Para?
Page para 7. The law of limitation is founded on public policy. Founded on public policy, it is enriched in the legal maxim, interest replica cutzit pens lutium. That is, it is for the legal welfare that a period of limitations be put to a litigations. The object is to put an end to every legal remedy and to have a fixed period of life for every litigation, as it is futile to keep any litigation or disputes pending indefinitely. Every public policy requires that there should be an end to the litigations. Otherwise, it would be a dichotomy if the litigations is made immortal. Vice versa, the litigating parties, that is human beings who are mortals. Now, section 9, it's explained, para 9 is explained about section 3, 10 also section 3. Now, I will come to straightway para 12. In view of the above provisions, the appeal which is preferred after expiry of the limitation is liable to be dismissed. The use of the word shall in the aforesaid provisions connotes that the dismissal is a mandatory subject to the extent exceptions. Section 3 of the Act is peremptory and had to be given effect to even though no objections regarding limitation is taken by the other side or referred to in the pleadings. In other words, it casts an obligation upon the court to dismiss an appeal which is presented beyond limitation. This is the general law of limitation. The exceptions are carved out under section 4 to 24 inclusive of the limitation, but we are concerned only with the exceptions contained in section 5, which empowers the court to admit an appeal, even if it is preferred after the prescribed period, provided the proposed appeal gives sufficient cause for not preferring the appeal within the period prescribed. In other words, the court are conferred with the discretionary powers to admit an appeal even after the expiry of the prescribed period, provided the proposed appellant is able to establish sufficient cause for not filing it within time. The state power
So you're saying that no sufficient cause has been made out. Is it?
out in this case.
Now, what about his submission that fraud was committed since all the children of the deceased was not listed out in the application before the district judge.
No, that will come only in the appeal because while considering the condonation application, merit is not to be discussed. Otherwise, if merit is taken into account, then there was no any requirement for these limitations to be come into pictures. Limitation is because certain period is fixed, time period is fixed.
Okay, what is the appeal? Let's look at the appeal.
Appeal, I have not, he had not served me the copy, I am not aware of that.
So in the appeal, your main contention is that you are also a legal heir, isn't it?
Yes, my lord.
Then,
Only, I am only praying for crossing of the judgment and order and decree dated 21/2014, my lord, and for direction upon the district judge to, my lord, implead us as a party, my lord, for
to
hearing of the
include
case.
it as a party.
My lord, 1998 7 SSC, my lord, for substantial, my lord, justice, my lord. Court can condone the delay, my lord. But this matter can be listed tomorrow, my lord, so that I can satisfy, my lord, for non-joiner of this party, my lord. This is also a suppression of material facts. I will place it on record.
Okay, heard about the parties? Let's start. Yes, tomorrow's date. Yes.
On this
Okay,
issue
leave it.
also, only I will submit a judgment.
Okay, because so many other cases also, then I'll pass the appropriate order tomorrow.
The case laws which I had submitted, it's covered everything. Even it had decided about the merit of the case, that it cannot be taken into account while hearing the condonation application. So I will be
So
relaxed
your submission is on the merits of the case.
on the merit.
While he is saying that if he's trying to satisfy the court that fraud has been committed
Yes,
in this instant case and it is not on the merits of the case. So we'll see you tomorrow.
ma'am.
Part heard, list tomorrow. Yes, so let's hurry up a bit, okay, because I think cases I tend to give too much of a patient hearing. Yes,
My lord, may I just make a prayer, my lord, out of turn? Lord, she has granted me permission, and I am told that two matters has come unlisted.
okay, wait for your turn. 13.
14. Mayor, Your
14,
Lordship,
yes.
I have already mentioned this item number 14.
What?
The conducting council is not able to appear today.
Who is for the respondents?
I have already taken consent from the
Okay, mention is made on behalf of Mr.
AK Singh.
AK Singh, Learned Conducting Council, for adjournment of the matter since the conducting council is not able to appear due to personal reasons. Okay, in view of the above, list after
2 weeks.
2 weeks on the date fixed by the registry. Yes.
Deeply obliged. Your Lordship.
Yes, what is the stage?
May I, Your Lordship? Your Lordship, here in this case, Your Lordship, I need some more time for filing counter affidavit, Your Lordship.
Okay,
There is an interim order, Your Lordship.
okay, Mr. So-and-so, learned counsel for the petitioner is present along with Mr.
E. Menjo,
Manager, learning counsel for respondents,
respondents.
private
number-
respondents,
All the private.
Yes,
private,
1 to 31.
private respondents, 1 to 31. The learned counsel for the respondents has prayed for further time to file the counter affidavit. Press allow list after 3 weeks.
2 weeks, Your Lordship.
In the
There is
meantime,
interim order
interim order passed earlier shall continue till the next return.
of like.
Yes.
My lord, here we have even taken fresh steps, my lord, but
Your Lordship,
Yes.
we have filed our Wakalatnama today itself.
Okay, you're the sole respondent.
Yes, we are the sole respondent.
Mr. So-and-so, learned counsel for the petition is present while Mr.
Ipayang.
Ipai, you filed it today.
Yes, Your Lordship.
Submits that they will be representing respondent number 1 and they have filed the Wakalatnama. And that they have filed the Wakalatnama. In view of the above, list after 2 weeks.
3 weeks,
3 weeks, okay. Oh.
deeply obliged.
Yes,
My lord, this IA is for condonation of delay.
Hmm.
of
What
six-
is the appeal about?
My lord, appeal against the conviction order dated 30/12/2021 passed by the district and session just passing.
Convicted for how many years?
7 years, my lord.
How many?
7 years.
7 years. Okay, and
This is a POXO case.
600, no, are we hearing the matter?
Your lordship, service.
So it's not listed for hearing today.
Yes.
Okay. So now the appeal has been admitted,
Admitted.
paper book received, paper book made, received.
Paper book is also
Received.
ready.
Okay, and
Please.
then respondent
Now,
number
only
2.
my friend is that the hearing of the main appeal maybe takes much time. And since the accused, the convicted person was in bail during the trial, first point. Second point, he has never misused the
Oh,
liberty.
so you are praying for the suspension of the sentence, is it?
Session.
But-
And he has been convicted only for a period of 3 years
But
under section 8 of the POXO Act.
But here it is already mentioned in the last court's order that the appeal shall be taken up along with the connected IA. Okay, so the IA has not been, okay, the IA has been put up, but it is going to be taken up at the time of hearing of the criminal appeal. So we'll fix a date. Paper book is received.
Yes.
Both the parties are represented. Okay.
No, no,
So
no
we will
doubt.
we'll list this matter for hearing. Give us a date, a short date, then we can hear the matter.
Appeal.
The appeal. Because this court has already said that your IA will be considered along with the appeal. So we'll go as per the previous order.
No,
Okay.
normally, IA should be disposed first, and after that, it should come to the main chair.
Since it's not going to take a long time,
otherwise-
everything is ready, so we can go ahead.
Yeah,
If
even
it
if
if it's going to take a long time, it's a different matter. That paper book is already received, everything is ready, paper, so we'll, this thing.
then
Okay.
let us fix it
Heard,
tomorrow
yes,
for
heard,
hearing.
Mr. Your good name, please? Adam Takar. Okay, Mohammed Pate, learned counsel for the appellant,
Yes, your lord.
along with Ms. So-and-so, learned PP.
Additional PP, your lord.
Additional PP for the state respondents and Mr. So-and-so, learned counsel for respondent number 2. It is seen that paper book is received and copies duly furnished to both the parties.
Furnish, yes.
Since both the parties are represented today, this matter may be listed for hearing on,
No, tomorrow, day after tomorrow, let us file.
list the matter after 1 week on a date to be fixed by the registry. Okay.
Fix date, we want to know the fixed date. The problem is that I'm having cases in many courts, so
Okay.
very difficult to exact.
On 5th August.
5th October.
On a Monday.
Deeply.
Yes.
Lordship, before my learned colleague proceed with the case, your lordship, this case on the first occasion when it was put up on 21/3/24, your lordship, there was an objection made by.
So let me get the correct case. Criminal petition number 40. Yes, item number 21. Yes.
So there was an objection stating that all the section in this case is compoundable. Now the petition has been filed under 482 for compounding of the offense. And since all the matters are compoundable, Your Lordship, under 320, all the compoundable matter is to be entertained by the magistrate, Your Lordship, not under 482. That was the objection made, Your Lordship. And the learned counsel was given time to make a research on that if he has any.
Yes, so what happened? Did you approach the, compoundable?
Lordship, in this regard, there was a preliminary objection. So in this regard, that based on the reference of this Honorable Supreme Court, Apex Court, the judgment, B.S. Joshi and others, based on that, the case diary was called. That same was admitted by this Honorable Court, that there is no limitation that only for these compoundable cases, they should approach to this lower court or high court. So thing is that
If the offenses are all compoundable, did you approach?
yes,
the victim?
in this regard, there is no case record in this lower court and in police station. So therefore, this might be 6th hearing before this honorable court.
So you have compounded the offense?
Yes,
You have already compounded?
Yes.
Where's the letter showing the compound?
yes,
the offense?
it's there in page number 21 and 22. That's mutual settlement.
With the victim?
Yes.
What is the case about?
It's about this victim has an alleged extramarital affairs with the this alleged accused.
Condonation of delay of
How many days?
50 days, 500.
50.
Yeah,
566 days.
50.
566. More than 1 year. So have you filed your written objection?
They have not filed any. Agreement.
You're not going
They
to?
haven't.
Third time.
Oh,
Extra copies is not.
Yours is up, sir.
It's not
Record
served.
will speak the truth.
okay. So heard Mr. So-and-so, learned counsel for the applicant, along with Miss
K. Wangu.
K. Wong, learned government advocate for the respondents,
Respondent number 1, 3, 4, 5.
for the state respondents. Okay.
There are other respondents also, ma'am. For 2 and 6.
None appeared for the private, are they private?
No, ma'am.
None appeared for respondents number
2 and 6.
2 and 6. The learned government advocate submits that they may be given time to file their written objection and that copy of the IA has not been furnished to them. In
No,
view
madam,
of
there is
that-
a record will speak, madam. Already I have given the extra copies also. They have received it.
Not them.
Then you give an extra. It is submitted that though the learned counsel for the petitioner has stated that extra copies of the IA has been duly furnished to
On
the
22,
government
4,
advocate. However,
2024, then
since the learned government advocate submits that they do not have a copy of the IA, the learned counsel for the applicant is to take necessary steps by first furnishing a copy of the IA to the learned government advocate. Yes. You take another step, otherwise the matter will be kept pending like this, isn't it? Unless the matter after 2 weeks for the learned government advocate to file their written objection. Yes. Yes, what is the matter?
Lordship,
Matter this 422 is to set aside a bail order pass by the learned session judge granting bail during trial.
Hmm.
My lord, my
Wait, who's respondent number 2? This is under section?
yes, Your Lordship, the service was through the Office of the Public Prosecutor, Your Lordship. We have served the notice upon the respondent number 2. And the same has been received, Your Lordship. I have just given the copy of the same.
Okay.
Your Lordship.
Who is representing?
None has appeared.
FIR is with regards to section 326 and 341.
My lord, the accused was charged with 302 and 3 witnesses have been examined And this, out of these three witnesses, two witnesses given 164 statement. They also came in affirm, and they happen to be the sisters of the accused. Now, when this particular order, which was impugned here, was passed, the factors about the severity of the punishment, about the crime seriousness of the crime, nothing was considered. And I respectfully take my lord to page 15 of the order which I have challenged.
Page 15.
15 of my application. 1.5. That's only, my lord, with your lord's permission. This application has been filed under 439 CRPC.
Just actually, my lord, I was there on the other court. Just, okay. In this case, just I haven't instructed.
Okay, respondent number 2.
Yes, through telephonically. I've been
Then we'll have to wait, you'll have to file your, so Wakalat Nama is there?
No Bakalat now, because the telephone, I've been on instruction, I'm.
Okay.
Well, in the case, my lord, may I humbly request your lordship to fix the matter on 12th of August for final disposal. For final disposal.
Heard Mr. So-and-so.
MGC.
MGC, Learned Counsel for the petitioner. Along with Ms. So-and-so, Learned additional PP for the state respondents. And Mr.
T. Tagum.
T. Takum, who submits, Learned Counsel, Mr. T. Takum, who submits that he will be filing his Wakalatnama for respondent number 2 within the course of the day.
My lord,
Within.
because as per bail condition, he cannot move out. We'll have to send.
We'll be filing his this thing shortly. Okay, Wakalatnama shortly. In view of the above, this matter on
12th of August for
So,
final disposal, if your lordship is pleased.
for final disposal, yes.
Meanwhile, the scanned copy of the updated TCR may also be called for your lordship.
It's not received yet. Meanwhile, scanned copy of the
TCR, your lordship.
TCR is to be called for. Yes. Huh? What? What is this? Okay, this is
That's the service complete notice.
Obligation, my lord.
Yes. Hearing.
This appeal. Matter is very simple. The impugned judgment was passed on 30/10/2017 by the additional session judge with session division both given. Now, I am not entered into the merits of the case. My appeal is only confined regarding the procedure which they have not taken in consideration. This is 428 of the CRPC. While the person was arrested and gave her custody during the trial court, those days are to be set off while the conviction was passed. But hearing the impugned judgment, though the accused person, the convicted person, was in the judicial custody 2 months, 26 days.
Wait, where's the appeal, this thing?
Judicial custody.
Appeal memo? Memo of appeal, where is it?
Memo of appeal is.
Let's see grounds for appeal.
Yeah, memo of
But I
appeal
can't understand what
page,
you say.
page 133.
Of the paper book?
Huh?
Of the paper book?
Paper book.
100?
100, page
133.
133. And a ground of appeal.
What are the grounds of appeal? Let's
Ground
see.
of appeal is para 8.
Para 8.
Para 8, page 136.
Yes.
Now, that the appellant beg to state that the appeal petition is filed by the convict to set up of the period of detention of the convict during the time of investigation. It happened that the convict, Yukar Tara, along with one convict, Tai Kop, was arrested on 13/2/2009 during the course of investigation. Then he was forwarded to the magistrate for obtaining remand. Accordingly, the judicial magistrate remanded the accused person for 14 days of police remand, which ended on 26/2/2009. Thereafter, the accused apparently was sent to the judicial custody, and until submission of charge sheet by the investigation officer on 6/4/2009, and he was released from the judicial custody on 8/5/2009. And even after the filing of the charge sheet, the convict person was in the custody as under trial prisoner, as his bail application was rejected on several occasions until 8/May/2009. He was granted bail. It is pertinent to mention here that the appellant convict was released on bail after 2 months, 26 days of police remand and judicial custody. Further, the learned court below, during the time passing of an order of quantum of punishment has failed to consider the aspect of provision provided under section 420 of the Criminal Procedure Code 1973, which mandated that section 428 period of detention under by the accused to be set off against the sentence.
So you're not against the conviction, you're for, concerning the sentence, you want the detention period to be set off. That's the only one?
Yes.
Okay, 1 year, he's been convicted for 1 year, sentenced to undergo imprisonment for 1 year. But detention period has not been set off.
Yes.
So the appeal is against the conviction.
Yeah.
The sentence, it's against the
Sentence.
sentence, not conviction. So what do you have to say?
In
It is
this,
for the setting of the, yes, detention period,
yes,
already undergone.
there is a provision.
So
to
we'll allow,
set up the undergone period.
yeah, so we'll allowed, okay, I'll pass the order later. Okay, so the sentence order is modified to the extent that the detention period already undergone by the appellant / convict is to be set off. Okay, yes. Yes, copy will be to, okay, we'll dispose of, allow.
Yes, that can be done.
Finish.
Obliged.
I'll pass the order later, okay, because many cases are still left. Yes, 28. This is dispose, the one just now, huh? We'll allow, we'll dispose, I'll pass the order later because it'll take time, huh? Chamber.
Hey, Lordship, I'm for the appellant.
Yes.
The case is today fixed for a hearing, Lordship. Regarding the MSc appeal, Lordship, I have challenged impugned judgment and award dated 04/06/2022. Pass the learned court below.
So the appeal is concerning the what amount?
Amount of 30 lakhs, 60,000.
Huh.
30 lakhs,
So you want
60,000.
enhancement, you are the claimant?
No,
You're the insurance company.
No, I'm the owner of the vehicle.
Owner, okay, you're the
Yes.
one who has to pay.
Yeah, learned court below has made me liable to pay
Okay,
the compensation to
uh-huh.
the.
Because
This
the
is
vehicle was not insured?
vehicle was insured, that's why I'm challenging.
Okay,
The
who's
during.
you're representing the,
For the claimant.
for the claimant, where's
for
the
the
insurance company?
Because the insurance company has to be insured.
Hmm.
Because I am challenging the validity of the insurance policy, Lordship. During the course of the incident, I have a valid insurance policy.
Okay, so
That
was
was not-
was the insurance company made a party?
Yes,
Before the tribunal?
It was a party.
In the tribe?
Yes.
Before, so insurance company was the
Was a
party?
party, Lordship.
So in the appeal, now in your appeal, you're saying the insurance company should be made a party, should pay the award, not you. Then insurance company has to be represented today.
Yes, yes.
So in the appeal, were they made a party?
Yes, Your Lordship.
Then-
That's OP number 2. I have made.
Then so where's
party.
respondent number 2? If they're not present, we cannot have the hearing.
Because he has to answer it.
Mhm.
Due to some personal difficulties, I was
Ah,
informed that
so-
he has left.
So then we'll
Also.
fix another date. We cannot hear
In
today,
this-
isn't it? It's as
regard-
simple as
Then
that.
after 3 weeks, Lordship.
Lordship, a small prayer in this regard. Lordship, actually, I am the claimant.
Hmm.
Now, this appeal has been pending since September of 2022. Now there is a stay in an IA filed by the appellant. Now, our prayer is that, Lordship, they have not deposited any security, the decreed amount, awarded amount, anything, but stay have been given and it was given ex parte without hearings. So
Oh.
the issue we are facing is for the past 2 years, we are unable to proceed with the execution. So now adjournments are also being taken on day-to-day basis. For the last, I believe, since November of 2023, it's been adjourned. Even before that, Lordship.
So you file an IA for, it has been in form of IA, no, for deposit of certain 50% of the award.
Lordship, we were trying to dispose it of
So
quickly,
we'll
Lordship.
fix a date. Now catch hold of the council for this insurance companies that doesn't run away.
Because
Okay, at the
Lordship,
time of hearing.
adjournment was not taken on the only part of me only.
Okay,
The party,
So-
OP number, insurance company and the
So next time.
council, they have also
matter is
taken.
listed, make sure you sit next to the council for the insurance company and hearing is held.
Lordship, we were praying
Because
for
they
it.
have
And
to be
regarding the
there.
payment of the security, at the time of the filing, it was settled long, but at the time of the hearing of the IA, which
So,
is
no, but insurance company has to be heard because you're
Yes.
trying to put the onus on the insurance company.
because they are the
to be
best person to
represented, yes.
answer the
Yes.
question raised by us.
So heard Mr. So-and-so, learned counsel for the appellant, along with Mr. So-and-so, learned counsel for respondent number 1. It is seen that respondent number 2 is not represented in view of the above. This is matter on 12th.
Lordship, we have a small prayer. If it could be this week or next week, Lordship.
Not possible next
Not
week.
possible.
Yes.
He is the appellant. So this is matter on 12/8/20.
Right.
24. Yes. To make sure insurance company is there. Now, there must have been an IA for deposit of money or something, nothing like that, 50% deposit.
Nothing was like. Now, Lordship, if order 41 is seen, Lordship, the onus is upon the claimant, Lordship. Even without claiming, Lordship, this honorable court may direct them to deposit the.
We'll see the next date if it's going to be adjourned again. Okay, then you can make the mention. Because this matter has been going on for a long time. Yes. 12th.
Lordship, can it be?
Table of us.
Yes, what is that? Unlisted item. What happened?
First case is concerned, only notice may be issued. I don't want, I'm not going to press for interim stay at the moment.
What is the matter about?
Matter will give an application under 482 for quashing of a charge sheet.
Washing of the charge sheet.
Yes.
And the charge sheet, you have been charged under what sections? of
Charge
law?
under section, my lord. All have 498A and 506.
498A.
Basically, my lord, if we have dispute between husband and wife,
Okay, we'll issue notice first.
only notice.
Heard Mr. So-and-so, learned counsel for the petition. For the petitioner who has filed this instant petition under 482 CRPC for washing of the FIR dated 19/03/2021, registered as WPS Teju Police Case
Your
number.
Lordship, If I may, your lordship.
03/2021.
If I may, your lordship, just
Huh?
interfere, lordship, this criminal petition. NBW. Sorry, your lordship, they have to say.
Under 21, what is section, under section 498A/506 of the Indian Penal Code. Now, this is filed today. No, you're still mentioning the Indian Penal Code.
No,
You
your
have
lordship,
to-
this case
No,
was
I-
filed in the
I have
principal
to
bench,
give
your lordship.
transfer of that. No, new act.
Principal bench, it was
okay,
transferred
okay, so
later.
it is transferred because of that. Otherwise, all new, this thing has to be with the new names, okay? Indian Penal Code, as well as the impugned charge sheet number 03/2021 dated 21/04/2021. Oh. It is issue notice to the respondents, Ms. So-and-so, learned additional PP, accepts notice on behalf of the state respondents. Requisite copy of the criminal petition is to be duly furnished to the learned additional PP. List after
3 weeks, your lordship.
3 weeks. Same?
I don't know, my lord, 30 million, I need, my lord, only some protection, my lord. Lordship may kindly suspend the, my lord, NBWA, and I will appear before the court and, my lord, make.
What, wait, let's see.
NBWA was issued on, my lord, Annex 12.
Now here,
I will just appear, my lord, Lordship kindly give me some protection. By you, my lord, recalling the NBWA. Because date was fixed on 29.
this was also filed before the principal.
Yes, your lordship. Both this matter are same. One is for quashing of the charge sheet, your
It is a
lordship.
different case.
The second one is for quashing of the NBW issued in this case, your lordship. The same case.
Not same case.
Same case, GR number 11. Fine.
Date was fixed on, my lord, 29/8/2024.
Let me just see your petition. So, non-bailable warrant has
Yes.
been issued against you?
Against me, madam. So, my lord, I will appear because I didn't receive any summon, any notice, nothing of this sort, madam. All of a sudden, I came to know.
So this is the same case,
Same, madam.
No, not
Petitioner
same
is the
case.
same.
different.
Petitioner is the same, your lordship. Different.
Petitioner is the same. He's a government employee. My lord, gazetted officer. This matter relates to some land dispute.
Okay, heard Mr. So-and-so, learned counsel for the petitioner who has filed this application under section 482 CRPC. Praying for cancellation, recalling or setting aside the non-bailable warrant of arrest issued against the petitioner. So in this case, the petitioners are the same, is it?
Petitioner is same,
Same person.
but case is different.
This is, so in this, it is only for staying of the
Yes, all the.
non-bailable. It is not for setting aside of the,
No, at the moment, my lord, I will appear.
nothing of that.
Just for, my lord.
For quashing of the proceedings, nothing like that.
No, nothing.
Your lordship, if I may, your lordship,
Oh.
this matter can be disposed of at this stage also, your lordship, because the only challenge they are making is of the NBW issued, your lordship.
Oh.
The matter is fixed on 29th of August, your lordship. If you lot
29th of August.
for next date for appearance, your lordship.
By the time, my lord,
For appearance, where's the order?
The last,
okay, at page,
the last,
last page. Last line.
Last page means what?
Last
Page
103.
103. Okay. The learned counsel for the petitioner submits that the instant NBWA may be stayed since the learned Court of Judicial Magistrate First Class, Namsi District, Namsai, okay, District, in its order dated 22/05/2024, had fixed 29/08/2024 for the appearance of the petitioner. The learned counsel submits that the petitioner will be appearing before the
And appear and take part in.
will be appearing before the Court of Judicial Magistrate First Class, and therefore the instant non-bailable warrant of arrest may be stayed, since execution of the non-bailable warrant of arrest would cause unbearable suffering, okay, to the petitioner. I'll just make up what you're supposed to submit. Okay, Miss so-and-so, learned additional PP, has not strongly objected to the staying of the non-bailable warrant of arrest, subject to the assurance that the petitioner.
Your Lordship, if I may, Your Lordship, Your Lordship may, as per my submission, Your Lordship can stay the, set aside the NBW.
Non-bailable warrant of arrest.
Yes, not set,
Subject to
not
her-
set aside, Your Lordship.
Stay,
Your Lordship can
stay.
stay the NBWA till 28 and on to 29/8/2024 on his appearance before the learned court, Your Lordship. He may file a proper bail application.
Okay, wait, subject to the condition that the petitioner appears before the learned court of Judicial Magistrate First Class on 28/08/2024, so that the petitioner can apply for bail before the concerned court on 29/08/2024. That's a submission, that's a submission, okay. Having heard the submissions made by the learned counsels for both the parties, this court, considering the fact that the learned counsel for the petitioner has given assurance to the court that the petitioner would make appearance before the Court of Judicial Magistrate First Class, Namsai District, on 29/08/2024, find it fit to stay the non-bailable warrant of arrest issued by the learned Court of Magistrate, Judicial Magistrate First Class. And the petitioner is to make his appearance before the Court of Judicial Magistrate on 29/08/2024 for further necessary steps. Yes, accordingly, so and so stands allowed and disposed of. Yes.
I'm grateful to your lordship.